yesterday lordship has granted the bail lordship. Regarding lordship, police in civil dress picked up a person lordship. That person escaped from that custody lordship. That matters lordship. Highly.
Please, your lordship. Lordship, I beg to mention item 52, lordship. Lordship, the CD has not come. Also, lordship, the parties are contemplating a settlement.
Everybody of judgment as well. Item? Not received. He did not receive police take on
27th of February. 26th February.
There's an interim, lordship.
Lordship, I beg to mention item number 62 and 6.
Lordship, we are for the applicant. I'm for the applicant.
$63.
The senior has some personal difficulties too.
Learned counsel for the yes,
Others.
For the applicant, lordship.
your respondent.
Speaks on
Yeah.
29th of
Your respondent.
again listed on 29th of January. This
All right.
obligation. Lordship, another prayer is I beg to mention item number 46.
Interim may be continued in item 62 and 63. It's interim.
First, let to continue. Yes, next item.
Item number 46. Lordship, not received. There is interim
6. He did not receive list.
interim.
Yes. May it please your lordship. Lordship, I beg to mention item number 29 of the daily list. Lordship, I think CD has not been received. So lordship may kindly call for the CD again, and we are on interim.
29. Same. Interim continues.
17th of February.
Lordship.
May I please, I beg to mention also item number 55 of today's list, my lord. There's some personal problem, my lord. CD is available here, my lord. It is second bail application. You also may take upon 2 on 2nd or 3rd February, my lord.
Item number
55.
even item. 55 CD received.
My lord, due to personal problem, my lord.
CD received. The prayer of learned counsel for the petitioner. Is the matter again on second
3rd February, my lord.
CD received B retain. Retain.
Yes, sir.
Lordship, I beg to mention item number not received. Item to be continued.
All right, same order.
May I please, your lordship? I beg to mention item number 28. CD was called for, CD was not received.
What one?
28. Interim may be continued.
Same. Willing to continue. Give a date.
11th February.
Earlier, the bail petition has been disposed of by this honorable court. And my lord, this application, my lord, arising out of same FIR. My lord, today, my lord.
Will it be possible?
Time permits, my lord.
But Reopening 27th.
Obliged.
Lordship, I beg to mention item number 57. Lordship, CD is received, the matter may be taken up after a week.
27.
57.
CD received, my lord.
All right. CD received on the prayer of learned the petitioner. The matter on.
Much obliged, Your Lordship.
May I please also? I beg to mention item number 49. Clerk not received. On interim. CD not received, my lord. Interim order contained. Deeply
May it be
obliged.
pleases your lordship, pertaining to item number 48, your lordship, on the last occasion CD has called for. Your lordship, this same CD has not received. So kindly I may pray for a short date, your lordship, after reopening 29th. 29th. I'm deeply obliged.
May I please, your lordship? I beg to mention item number 26, lordship. Kindly adjourn for the day, lordship. Interim order shall continue, lordship. 26.
Not received now.
Says which Kent is here,
Kent is here received, man. Yes, in this.
but CD is not.
Kent is here already received, man.
You need the CD
Already CD is there along in
in this record itself. Copy of TCR has been received on the prayer of learned counsel for the petitioner list again on.
Interim order shall continue. Oblige, your lordship.
Fair please, Your Lordship. My lord, I beg to mention item number 77 for upgradation and matter will take at 2 p.m. my lord.
Why?
My lord, the last time the matter was listed on 7th of January, my lord, and it is left over. Then it was fixed on 9th of January, but the matter was not listed.
Happens all the time.
My lord.
We'll go serially.
My lord, the petitioner are not on interim, my lord. As CD is also available, my lord.
We'll try. Let us see. Let us proceed.
My lord,
Yes.
highly obliged, my lord. Your Lordship. Lordship, item 15 of today's list, my lord. Lordship, this matter is fixed at 2 p.m. And on the last date, a reminder was issued for the report. But the report has been received by the state. But can we get a copy of the report so that we can proceed with the hearing? Since we didn't receive a copy. Our matter is fixed at 2 p.m. madam.
Yes.
Here, well, I will have to check one, in my file, one
Exact.
report is annexed.
If
Yeah.
copy is there, you supply it to them. We'll see at 2 p.m. then.
Obliged, madam.
If photocopy going to
Yes, sir, I beg to mention item number 56. Kindly adjourn the matter for the day. 56.
56.
56.
Again on.
30 January.
No, she did not receive money.
30 January. No, sir, another pair 51, kindly maybe added. Item number 51.
51, my lord, case diary received, my lord, in this case.
Some
He
problem.
received on prayer of learned counsel for the petitioner list.
2nd February.
Yes.
For one.
The petition is allowed.
I'm obliged.
Number 68.
Prayer for bail is allowed.
Highly obliged.
And for motion. From supplementary list 69.
Wait, please, your lordship. It's a regular bail application, my lord. FIR is at page number 18. Where is the FIR? The case of 69 BNS, man. Basically, my lord, the petitioner as well as this informant, my lord, they are from two different religions, my lord. So as such, my lord, perhaps this breach of promise to marry will not arise, my lord. There were some differences with regarding, my lord, this religion, my lord. That's why, my lord, the marriage could not take place and she lost this affair against this present petitioner, my lord. Cannot be a case of, my lord, breach of promise to marry. FIR itself says that, my lord, আনহাতে বিয়া হব লাগিলে মই মোৰ হিন্দু ধৰ্ম ত্যাগ কৰি ইছলাম ধৰ্ম গ্ৰহণ কৰাৰ বাবেও জোৰ কৰিছিলে. It cannot be a case that, my lord, he had refused to marry her, but the thing was that regarding conversion and all, my lord, there was some dispute. That's why, my lord, the marriage could not take place, but the petitioner is still willing to marry this girl. So, prima facie, my lord,
Second page,
my lord.
forcefully picked up.
My lord,
Second page.
I'm reading from page 18. The vernacular.
I'm on page 17. Asking to meet me without my permission, forcefully pick me up.
This was the day, my lord, when they went for marriage, and because of the objection from the girl's family, he had to leave her in the local police station, my lord. Otherwise, my lord, there is no case of, my lord, breach of promise to marry. Lordship will kindly see the FIR, my lord. It cannot be a case that, my lord, he had refused to marry her.
The allegation is of abduction. How many days?
7 days, my lord.
Only 7 days.
7 days.
Let's have the CD.
Second, 3rd of February.
Third. CD, man. Highly obliged.
Item number 2.
2 and 3. Wait, please, also, my lord, item number 3, my lord. Here, my lord, lordship has earlier called for the case diary, my lord. It is wrongly listed as, my lord, bail hearing, motion, my lord.
Does the CD come?
No, my lord, CD not come.
What about 2?
My lord, same
my
case, my lord,
Same
same,
case, from the same affair.
same affair.
And 3, CDS call for has not been raised. Is the matter in the bail hearing column and the next day.
But item number 2, CD was not called, my lord. Item number 3, CD was called.
Oh,
Lordship may pass-
Same CD.
Lord-
Yes, same CD.
Same CD, lord. Lordship may fix it.
Yes.
My lord, 5th of February.
Oblige your lordship.
Magistrate, pre-arrest bail application, my lord. Lordship will find the FIR at page 18, my lord. There 4/1/24, my lord, some vehicle was intercepted and recovery of fake currency was made. Subsequently,
Was it rejected earlier?
no, my lord. Fake currency of 60 lakhs, my lord, of fake Indian currency. 18 is the FIR, my lord, page 18. My name is not in the FIR, my lord.
We'll have to see CD. Okay.
Can I be protected, my lord, because
This is the question of protection now.
12-2.
And our part.
May I please your lordship? Here is bail application, my lord. Case registered under section, my lord, 61-2, 1152 and 103, that is murder, my lord.
All right,
No.
CD.
Shorted maybe, he is 65 years old person, my lord. He was not present in the incident. Please go. Okay. Yes, ma'am.
May I please, lordship, without FIR, my lord. Case is filed, my lord. Call for the my lord, report whether any FIR is pending or registered, my
All
lord.
right, call for a report whether any FIR is pending against the present petitioner. Which police station?
Palkasia, my lord.
Mosi Kolgusia Police Station.
Obligation.
May I please, lordship? FP bail, my lord. FIR is page 10, my lord. Translate portion, my lord. Vernacular is page 12, my lord. May I read, my lord? Allegation is serious, my lord. Rape allegation. Allegation is serious, my lord. Rape allegation, my lord. May I read, my lord? বিহিত নিবেদন এই যে গত 16/12/25 ইংরেজি তারিখ রাত্রি অনুমান 9 ঘটিকায় আমার গৃহের টিনের জালানা ভাঙিয়া প্রবেশ করিয়া আমি শুই থাকা অবস্থায় আমাকে মুখে হাত দিয়ে চাপা মারিয়ে আমাকে ধর্ষণ করে ও ড্যাগার দিয়ে ধমকি দিয়ে আমাকে বলে যে হাল্লা চিৎকার করিলে মেরে ফেলবো। এতে আসামি আমার সাথে প্রায় আধা ঘন্টা ধর্ষণ করে চলিয়ে যাওয়ার পর
Yes, yes,
আমি
what is your
চিৎকার
submission now?
my lord. Is it very false and fabricated FIR, my lord?
CD.
Allegation is serious, my lord.
Yes.
CD, my lord, that is 10th, my lord. 10 February, my lord.
Lordship, first of all, the just timing, your lordship. Learned arguing counsel is on leg, your lordship.
May I please, lordship? In this case, my lord, FIR at page 9, my lord. May I read, my lord? The allegation is, my lord, setting fire in the houses, my lord, and also some I am for the accused number, my lord, 2, 3, and 4, my lord. One has already been arrested, my lord, and we also filed a cross case, my lord. The fact is that, my lord, the petition number 1, the sister of the petition number 1 has been killed. He has been suspected to have been killed by the brother-in-law of the petitioner, my lord. In this regard, my lord, I also the petition number 1 also lost an FIR at page 17, my lord. The victim has been made the victim, my lord, in this FIR, my lord.
And CD, my lord, from Hazu, my lord.
My lord, in this case, kindly protect, my lord.
We protect that case.
My lord, 10th, my lord. 10th of February.
May it please your lordship. Also, this is an anticipatory bail application under BNSS. Similar cases arising out of the same merits or PS case 45/20/25,000. So that is fixed on 6/2/26 for CD and PMR. So my case is also tagged with that.
Is the matter along with
AB 2967/25
on?
on 6/2/26 for CD and PMR. Obliged.
Public 70.
May I please, your lords, it is along with item number 23, and in 23, when the case diary was called for.
Number 23.
Three. Same affair. my lord.
I will take it with 23 school.
Along with 20. এখন 23 নাও আপনি।
23 মাত্রতে দিব।
Yeah, please, your lordship. Lordship, anticipatory bail in this case, FIR is at page 12, my lord. Exact what?
Page?
Page 12, 1 to 4.
TD, my lord.
My lord, simple paragraph kindly may perused at page 5, your lordship. At page 4, from below part, page 4, your lordship.
My lord, before that FIR, my lord, page 12, my lord, last part, my lord. Page 12, my lord. Translated copy, my lord. Present petition আমার নূর হোসেন ম্যাডাম।
And page kindly perused at 4, below, from below portion, my lord. When the said meeting was over or finished, then the informant was sent back to her residence by e-rickshaw at about, it will be 7, your lordship, I am sorry, 7 p.m. with the petitioner and one maternal uncle of the petitioner, namely Mohibul Haq, and another prominent social worker, namely Sofiur Rahman. 3 persons went by e-rickshaw
How
to
do we
drop
know?
her at her residence, my lord.
How do we know?
But as per the statement, so kindly may record the statement of the accused. And
All right, CD only.
My lord.
kindly protect.
10, my lord, 10, my lord. 10.
Published.
Thank you, lordship. My signal is busy for another court, lordship. Matter of time being, lordship, kindly.
Lordship, I was directed to file affidavit, Lordship,
Lordship, so many taken time, lordship. Kindly wait for my senior just come.
but would not contact Lordship.
Let them come.
In the
last order, my lord, your lordship was pleased to call for the record, my lord. Record is not available. Mike has this other.
TCRS call for has not been received. Registry is directed to issue reminder. The principal judge, family court, Borpeta. Directed to ensure transmission of the here. Next date fixed, list matter again on.
I have filed Kalatnama yesterday, Lordship, for respondent, Lordship.
Net council has entered appearance for respondent number.
Respondent,
Sole respondent.
sole
For
respondent.
the sole
Lord,
respondent.
this our court was pleased to appoint MIS, my lord. In the earlier
The
occasion.
services of amicus. Therefore, dispensed with.
Lordship.
Interim order passed earlier to continue.
License.
Bless you.
Please, your lordship, the matter pertaining to the rim of the vehicle which was seized by in connection with the case, my lord, of NDPS. My lord, the vehicle is behind the bar.
Vehicle
Since,
is
my
behind
lord,
the bar. Vehicle is behind the bar.
Yes, vehicle is in the police station, my lord, after seizure, and it is being damaged badly because of the time factor, my lord. And accused are also behind the bar, my lord. I am not for accused, my lord. My lord, actually it was a registered vehicle in my name, and I have given on rent for the purpose of the wants to, my friend wants to run it, my lord.
Your DRI is the party, my lord. First there.
Here,
এটা কি কি পড়া ও
DRI case.
matter is long pending, my lord, on the, because they have filed objection, we have given reply of it also. And your
No, but
lordship
in the court below,
rejected it.
rejected. Where is that order?
Order is, my lord, at page 29, my lord.
Where is the part dealing with the JIMA application?
My application, my lord.
No, where is the part of the order dealing with your JIMA application?
My lord, page 34, kindly peruse, my lord. The opinion of the court is that it is an integral part of the investigation, my lord. That also I admit, my lord, that is one of the factor, no doubt. But I will produce it whenever it is required, my lord. Others,
Who knows, you will not re-modify it.
my lord, latest judgment of the apex court.
Show me a judgment of the apex court where in the similar circumstance,
Yes.
where a modified vehicle is allowed.
But the Supreme Court has discouraged that it should not be detained for a long time because ultimately it will be a scrap iron.
Subject to exceptions.
Yes. So, my lord, under any condition, your lordship, I am placing all the judgment, my lord, Bishwajit Dey, as well as my lord, latest judgment of this effect to Ashok Kumar, state of Bihar.
Your lordship, in this matter, I have not yet received the reply till the reply file.
Well, we have
Every-
submitted the reply. क्या बात हो?
Every date I ask for a copy of the reply. Whatever they have written, I am not,
Reply नहीं दिया नहीं
till date I have not received it. And also, your lordship, in our objection itself, the petitioner himself is an accused. So as per the conditions laid in the Bishwajit Day case, the vehicle cannot be released on Zimba. Law is settled.
Will you accept it?
Yes, yes. Oh, good.
चला गया अपने पैसे तो दिलूंगा ऑफिशियल डिसेबल क्वेश्चन यस अपना ऑफिस डिसेबल क्वेश्चन एनीवे गॉट इट
I just like to place the Bishwajit Day judgment, your lordship, for it.
Both of you are relying on Biswajit Day.
My lord, Ashok Kumar for the state of Bihar, would you not think it necessary to keep the vehicle in the compound of the court indefinitely for a period of long time till the final disposal of the case? It is more advisable to entrust it to the registered owner on behalf of the court under certain conditions. We therefore direct the court to
whose custody the vehicle is presently kept to release in same appellant to the following conditions, my lord.
There are 29 of the Biswajit details.
Can you see? This is the apex court, latest judge. Then,
After Biswajit, there is the latest one.
yes. Moreover, my lord, this Sundarbai Ambala case is still, it didn't get the consideration of Gujarat. Then I am placing two judgment of my own high coordinate bench, my lord. Jaldi. Jammu and Kashmir, my lord, our own high court, Nahu Doimari. Then Sanjay Dwivedi of the Madhya Pradesh High Court, my lord.
Here the owner is an accused.
Maybe, my lord.
So you were just now speaking about Biswajit there. Look what he said there.
My lord, other judgment also have placed, my lord.
Show me which of the other judgments was a case where the vehicle was modified with special chambers for carrying contraband. Facts of the case.
But I have rented out it, my lord. I was made accused because of the I am the owner of the vehicle.
In Biswajit Day,
Nothing was recovered from my
categorically,
position, my lord.
it is stated, this court is of the view that criminal law has not to be applied in a vacuum, but to the facts of each case. Then
But nothing was recovered from
There cannot be a
I
reason.
was made accused because I am the owner of the registered owner of the vehicle. That's why I was made accused, my lord.
You have stated in the objection how he was the main perpetrator of this whole business. He is the conduit and the main person. And the accused, the persons were arrested. He was the one who handed over the drugs as well as the vehicle.
In that case, the Tamil Nadu judgment, your lordship knows, my lord. Co-accused state. I am registered on. I have given him on rent, my lord. Who knows that he will be utilizing for peddling drugs, my lord?
Not only the statement of the co-accused, your lordship, in fact, we have also mentioned the call details between the petitioner and the arrested accused person. How he has been actually directing all this whole business. And it's not a small consignment which was actually seized, your lordship.
all right, that is all.
Yes.
Right, CAB.
Lordship, my name may be recorded.
Yes, but Mr.
Developer.
Your name?
Senior Senior Counsel, DRI.
Appearing for?
Here.
DRI. Documents.
On last several occasions, the case diary was called for because they have retained my cash money and for which I have an explanation, I have given it on record.
Regarding one Jimma report that is available in the file, my lord. Regarding the CD, my lord, because matter is listed in admission, so I will have to check my office, my lord, whether CD is available in our office.
Fix another date, but they should ensure. Your lordship may fix another date, we have no problem, but they should ensure that the case diary comes on the next day.
Alternate date.
10 dates have gone, I think.
Additional PP. Press for some time to
27th of Lula. Dila.
Time to find out whether the
Probably CD is whether in my office may be available, well, I will have to.
But let it, your lordship, I have it on 27th. We
raise the matter again on
20.
20.
We are obliged. Sir.
Run it additional PP to positively intimate on the said date as to whether the CD has been received.
We are obliged. Sir.
Please, your lordship. It's an anticipatory bail application. There are two FIRs, my lord. A robbery took place in respect of which an FIR was lodged. Subsequently, the family of the robbers, they lodged an FIR. Your lordship will find the first FIR at page 11.
Page?
Page 11, madam. May I read, madam? Page 11. Sir, with due respect, I humbly submit that the below mentioned two accused persons and two unknown miscreants have been threatening me over the phone with various kinds of life threats and intimidation. And from about 3 days ago till today, they have been demanding 2 lakh rupees from me. Demanding the said money, the group of 4 miscreants arrived at my own residence today, that is on 4/12/2025 at approximately 4 p.m. in a white color Bolero vehicle bearing registration number so-and-so. When I delayed in giving the money to the said accused persons, one of the miscreants in the group took out a pistol and struck me on the head, injuring me. As soon as I shouted, the local people came and rescued me and caught hold of the 2 of the 4 miscreants and informed Sapor police station. It is stated that during the scuffle with the public, they managed to throw away the pistol magazine and escape. Now, these 2 persons, my lord, Latif Ali and Abdul Majid, they were apprehended by the local people, my lord, and this informant was rescued. These 2 persons were arrested, my lord. Your lordship will find. Sorry, my lord. Now your lordship will kindly come to page 18, my lord. That FIR was lodged on 4th, my lord, on the day of the incident. Now, page 18, Latif's father lodges this FIR, wherein I am seeking anticipatory bail, my lord. May I read this FIR, my lord?
Page 18 is the FIR of the present case.
Present case, my lord. This was lodged on 9th, my lord, 5 days after the first FIR. Sir, with due respect, I humbly submit that about 15 days ago, the below mentioned accused number 2 enticed and lured my son Latif Ali by showing temptation that if he gives 2 lakh rupees to accused number 1, the accused would return double the money. Accordingly, my son took cash of rupees 2 lakh with his friends, namely so-and-so, 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 and on the afternoon of 4/12/2025 at around 4 p.m., went to the house of accused number 1 along with accused number 2. As soon as my son and his friends arrived at the house of accused number 1, the accused persons in a pre-planned conspiracy forcibly snatched away the 2 lakh rupees that my son had bought with him. In addition to that, with the intention of killing my son and his friends, the accused persons assaulted them with sharp weapons and caused serious injuries to various parts of their bodies. Seeing the violent attitude of the accused persons, my son's friends, Firdaus and Mithu, ran away from the spot out of fear for their lives. Thereafter, the accused persons unlawfully confined my son and Abdul Majid inside the house of accused number 1 and falsely informed Sapor police station, claiming that my son had gone to the house of accused number 1 along with his friends to demand money. Later, when Sapor police arrived at the scene and were taking away my son and Firdaus Ali, the accused persons falsely handed over to the police 1 pistol without bullet and magazine, saying that they had recovered it from my son. Along with that, the accused persons also handed over the police the 4-wheeler Bolero vehicle bearing registration number so-and-so, which my son had taken. It is stated that later we came to know that the accused persons, acting together in collusion, have previously been luring various people in this manner, calling them to their house, snatching money and misappropriating it. So this is basically their defense to that FIR, my lord, of 4th, where this petitioner informant's son was arrested, handed over to the police arrested them. Now they've created this defense in the form of this FIR, which was lodged after 5 days. And in this FIR, I have been named. I was one of the persons of that locality who, when that incident happened, went and rescued that informant, madam, and handed over the accused to the police. They've built up a very good defense, explaining every incriminating material which is there in their FIR against them, madam. They've explained the presence of the pistol. They have explained the presence of the vehicle. They have also explained the presence of the money, which they were trying to rob from the informant in that case.
These persons, Latif Ali and Abdul Majid, they were handed over to the police.
Please, my lord. Subsequently, they were granted bail. Your lordship will find their bail order at page 28. I'm not even the informant of that case. So I was just there because that incident happened. Went there, rescued him and called the police.
Yes, PP.
It seems that, my lord, everything is confusing, but one fact is clear that, my lord, that one pistol was recovered from the possession of the accused persons, my lord. Maybe it is of the, my lord, informant of the accused, my lord. Otherwise, my lord, the fact is that the pistol along with the accused person was handed over.
Where
to
is
the
that?
police. That is, my lord, in page 19, my lord.
In the FIR,
In the FIR, my lord.
And that is the claim, is it not?
Claim. But whether that pistol is, my lord, armed, my lord, license, having any license or not, my lord, why these persons kept keeping all that pistol along with them, my lord.
No, who is keeping, who is not keeping? They say that they came with the pistol. He says that when they showed them the pistol.
Only CD will reveal, my lord,
is
the actual fact.
their case that they when FIR was lodged on 4th, they were handed over on 4th. 5 days later, they come up with this story where they try to explain each and everything because the allegation was that they had come with a pistol, attacked them and tried to commit robbery. Now they here say that everything was done by these persons and everything was planted. It is clearly an afterthought, my lord, just to get out of that case, my lord. Perhaps to build up some sort of a defense through which they can subsequently claim reasonable doubt in their case. Timing is also very crucial here. 5 days after that incident, 5 days after the person is arrested, this FIR gets lodged.
Third learned counsel for the petition. And additional PP. An application under case 22. It is Krishna. The present FIR is a counterblast to the when earlier FIR lodged against the informant of the present case. Who is the informant of the present case?
Abdul Hamid, my lord, page 18. He is the father of Latif Ali, my lord. And that your lordship will find in page 12.
Blast to a case lodged against the son of the informant of relating to an incident wherein it was alleged that the son of the present informant along with other persons had gone to the house of the petitioner and
Not the petitioner, my lord. Petitioner's
No, no.
neighbor.
house of the informant of the said case and demanded money. On hue and cry being raised, local people arrived, got hold of the son of the informant and handed them over to the police. Present fire has been lodged 5 days after the said incident. That the allegations made herein are false and are by way of a defense to the allegations contained in the first FIR. Call for the CD, having regard to the above, that is provided in the interim that in the event there is the petition shall be released them interim pre-arrest bail of rupees 50,000 with one security, like connection with the FSA. Satisfaction of the arresting authority, it is provided that the petitioner shall appear before the IO within a period of 7 days. Ten days, you can keep 10 days. 25. Deep level. Look at case late.
I was directed to file the affidavit. I did ring, did WhatsApp messages to the respondents, but yet to contact them.
Only
One
for
more
giving-
chance, Lordship. One more chance.
As a last chance, my lord, because so many.
Learned counsel for the respondent submits that due to inability to communicate with the respondent, he has not been able to submit the affidavit. Prays for one more chance. Hard learned counsel for the petitioner, having regard to the aforesaid submission, one more chance is granted to the respondent to submit affidavit. List again.
Can it be before 10, my lord? 7.
17th.
All right, 17.
Publish. Well, item number 16, search sheet submitted in this case. The petitioner is also granted interim bail, my lord. By order dated 14th of October. Paste.
Can copy.
Yes, sir.
Submitted that CS has already been submitted by
Case number 243/25, dated 23/10/25.
call for the scan copy of the TCR with CD.
Date, my lord, on 13/2, my lord.
Lordship, the CD has not been received in this case and it has been registered as PRC case 170/2025 in Hunza, Your Lord.
Seventeenth, my lord, CD not received, my lord.
It has been registered as PRC case. Answer.
Petitioner is an interim, my lord.
Trial court record may be called.
It did not received. The case is registered as a PRC case, call for the copy of the TCR along with the CD. Release the matter again also and so. Interim order passed earlier to continue. Next date of.
25 to second of October.
Obliged.
Short sheet submitted in this case.
Well, in this case, your lordship was pleased to grant us interim bail, though it's a regular bail application. Lordship was granted us bail primarily on one ground that, my lord, the accused were not produced before the learned magistrate within 24 hours. My lord. I mean, these are otherwise, my lord, all magistrate tribal sections, my lord. So extortion and cheating, my lord. If we inclined to make it absolute, my lord, we'll cooperate with the trial, my lord.
Where is the FIR?
FIR, your lordship will find at page 12, my lord. May I read it, my lord? Sir, with reference to the subject cited above, I have the honor to inform you that on receipt of reliable source information at about 8 p.m. on 18/10/2025, it came to light that certain miscreants were indulging in fraudulent activities by deceitfully replacing ATM cards of unsuspecting citizens at ATM booths without their knowledge. The source further reported that the said persons were moving about in the Borghat area and were using such fraudulently obtained ATM cards for wrongful personal gain. Accordingly, a GD entry was made by so and so number dated 18/10/25. And the officer in charge, Nagaur Police Station, was duly informed. Subsequently, my lord, next paragraph, the said team proceeded towards Borghat Chowk using departmental vehicle during surveillance in the area. At about 9:15 p.m., 4 persons moving suspiciously in a vehicle were apprehended. So these were the petitioners, and your lordship will note that they were apprehended on 18/10/2025, my lord. Now, your lordship will kindly come to the otherwise, scan copy of TCR would be required, my lord, because well, only from the record, my lord. Because what had happened here in this case, my lord, these petitioners were arrested. They were produced 2 days later, and they had already been beaten up by the police. We had also complained to the magistrate, and in that regard, the magistrate had already written to the State Police Accountability Commission as well as the Human Rights Commission, and proceedings have already been initiated against the police officers, my lord. That your lordship will find at page 38, my lord, relevant at page 40. 2 days, these persons were picked up because they were not court red-handed. They were picked up on suspicions. 2 days, they kept them in the police station, beat them up, severely injured. When produced before the magistrate, magistrate finds injuries on them and writes to the State Police Accountability Commission and Human Rights Commission, my lord. And considering these two aspects, your lordship was pleased to grant us interim bail. Now, whatever be the merit of the case, that will come up in the trial, my lord. We are already outside. So no point in again getting us inside when the investigation is already over.
My lord, regarding the my lord, harassment by the police officer regarding those police accountable, those are the different aspects.
Those are different aspects, but even if we call for the copy, the fact of delayed production, that will not change. Is it?
Yes, that will not change, but my lord, for that reason, because at that point of time, on the basis of the submissions of the petitioner, your lordship was pleased to grant interim protection, my lord. Prima facie, my lord,
Not just on the basis of submission, I think it was.
Based on records, my lord. Page 30th on 20th, they were picked up on 18th. This 2-day period is sufficiently explained by the torture.
your lordship, my lord.
These are magistrate tribal cases, so. An example for the people. Submitted that CS has already been submitted in the case. By. Order. Dated 2025. The granted interim. The ground of. Delayed production before the magistrate. Beyond 24 hours. Violation of Article India. Having regard to the above. This. And petition is disposed of by. Making absolute the. Hearing order dated 27/11/20.
I'm deeply obliged, my lord.
Right, please. My lord, 21 and 22 may be taken up first, my lord.
My lord, 19, 20, 21 and 22. The same
Argument.
scan copy of TCR was called for, my lord. Scan copy of TCR received, my lord. And
Yes.
take with item number 22, my lord.
19 to 22.
Yes, yes. That is, my lord, regarding that NEF student, my lord.
Yeah, my lord, only thing, my lord, with all respect, my lord. Juvenile delinquency, my lord, very unfortunate thing has happened, my lord. Initially, my lord, the fight started because of some, my lord, parochial comments, my lord. And anyway, my lord, with all respect, my lord, these are all students, my lord, just crossed their teens, my lord. And charge sheet has been submitted, my lord. And furthermore, my lord, with all respect, my lord, local residents, flight risk is not there, my lord. If they are detained also, my lord, and here it is not a case of that, my lord, with all further investigation is continuing, my lord. Part charge sheet has been submitted. It is not to that effect, my lord. To my knowledge, absolute charge sheet, no? Oh, sorry, my lord. Part charge sheet has been submitted, my lord. And here, my lord, with all respect, if they are detained, my lord, it cannot facilitate the further investigation, my lord, with all respect, my lord. And one authority, my lord, one, of course, my lord, that is not needed possibly, my lord. Just as a reference, my lord, with all respect, my lord. An MP from Gujarat, my lord, with all respect, my lord, he was involved in a 302 case, my lord. There he was granted the privilege of bail upon part charge sheet being submitted, like the present case, my lord. And the observation of the apex court, my lord, that occurs at, my lord. আর ধরি ধরি এসছে নয় মানুষ মন্দিরের কারণে ভিড় my lord, with all respect, my lord, that occurs at para 64, my lord. May I read? May I read, man?
Yes.
We have already noticed the submission of the learned counsel for the parties on this application, seeking bail in the main judgment. It was an appeal, my lord. The appellant petitioner was arrested on so and so when he appeared before the CBI in response to summons. Since then, the appellant petitioner has been in custody. The supplementary charge sheet has been filed by the CBI in the Court of Additional CGM Ahmedabad in January 2014. After the charge sheet being filed, obviously the appellant petitioner is no longer required for further investigation. Exactly the same observation, my lord. Although further investigation is continuing, my lord, regarding them, charge sheet has been submitted. Exactly the same, my lord, tailor-made. The appellant petitioner is no longer required for further investigation. This is of utmost importance, my lord. Mr. Rohtagi, has rightly pointed out that there is no likelihood of the appellant petitioner tampering with evidence, as the copies of all the sensitive documents have not been supplied, sensitive statements have not been supplied to the appellant petitioner. We stand on a better footing because copies have not been sent to us as yet, my lord. With all thereafter, my lord, he took a plea that he was an MP, so he was to be released on bail. Court rejected that, my lord, that it would be meaning thereby an 141 authority, my lord, para 65. We are not much impressed by the submission of Mr. Rotagi that the appellant petitioner ought to be released on bail simply because he happens to be a sitting MP. Meaning thereby, in a charge-sheeted case, when part charge sheet has been submitted, my lord, where is there no possibility of tampering with evidence or flight risk, my lord, possibly, my lord, keeping a man in custody is my lord, redundant, then thereafter the parting lines of para 65. However, keeping in view the fact that the CBI has submitted supplementary charge sheet, and that the trial is like to take a long time. Same thing here, my lord. We deem it appropriate to enlarge the appellant petitioner on bail subject to the following conditions, my lord. My lord, with all respect, my lord, local resident, young boys, some mistakes somewhere, my lord, with all respect and folded hands, my lord. If released on bail, they have stringent conditions, my lord, if released, my lord, with all respect, my lord, that they would appear on each and every subsequent day. One single default without showing proper cause would automatically lead to cancellation of bail, my lord. This much, my lord. With all respect, my lord. 3 months, 21 days, my lord. And my lord, co-accused. 3 months, 21 days we are in custody.
First charge sheet was submitted when?
Oh, sorry, my lord. In this case, not. In the case I cited, my lord, there the accused was in custody for 3 months, 21 days, my lord. Here, my lord, we are in custody for 4 months, 11 days, my lord. Quantum was we are on a better footing, my lord.
Charge sheet submitted on 8/12/25.
And one of the prime accused, my lord, with all respect, I should not say prime accused, my lord, he was also very much involved, my lord. He was granted the privilege of bail. And the accused persons were arrested initially on the basis of CCTV footage. But now, my lord, of course, my lord, primarily on CCTV footage. If I read that, my lord, I need not have to, should I read it? I should read it, my lord. The forwarding report. Some forwarding report
Could not be identified properly.
no, my lord. Exactly, my lord. Same, exactly. I should not read it, my lord. Anyway, my lord, even if there are materials, there may be materials, my lord. Only their attendance is to be procured during trial, my lord. Their incarceration in custody would not lead to would not facilitate the further police investigation, my lord, with all respect and folded hands, my lord. Our police investigation is only for the absconding accused persons, my lord, not the present ones, my lord. It is wonderful.
Charge sheet was submitted
Yes,
on?
charge sheet submitted on, my lord, 8/12/25.
That means within statutory period.
Yes, within statutory period. In the LCR, my lord, I have flag mark, my lord, there are 2 injured eyewitnesses, my lord. One is, my lord, Tenzin Jambel and one is Deva Palsler, my lord. Their statement, I have, my lord, flag mark. And regarding other eyewitnesses also there, my lord. Regarding their witnesses is also, my lord, I have flag mark, my lord. And regarding the
This was item 19, same submission in all?
19 to 20, 19 to 20, my lord.
19 to 20.
Same date of arrest, my lord.
And considering the nature, my lord, of the offense, my lord, how these accused person assaulted on that aspect, my lord, my objection may kindly be.
So if your objection is recorded, you are agreeable to bail.
No, my lord, otherwise.
That is the tenor possibly.
My objection is there, my lord, regarding, because, my lord, how brutally these accused person, they are all friends, my lord. How they brutally they assaulted even after when, my lord, after the, my lord, deceased person become unconscious.
He died
thereafter-
20 days thereafter, my lord. It may not
yes.
be a case of 103
After 20 days, my lord.
PNS, my lord. After 20 days, my lord. Innumerable authorities, my lord.
But prima facie, my lord, those after, my lord, that video footage, although, my lord, FSL report is something, my lord, regarding that identification of those accused, my lord, by the FSL, my lord, forensic expert, my lord. But otherwise, those eyewitnesses at the time of the, immediately after the incident, my lord, identified those, my lord, accused persons. My lord.
All right.
Obliged.
You supplement 10/70.
May I please, your lordship, the case diary was called for. Azahar is at page 10. On 1/1/26, the.
Received. Did you receive?
Yes, he received. Page 10, my lord, your lordship, kindly see. Accused number 6 and accused number 3. And one, my lord, petitioner Aizur Rahman, he was not the name accused, but accused number 6 and accused number 3 are the name used. Page 10. The time of forcefully committing the offense, my lord, see, my lord, video of the incident. How it is possible? Incident statement of the victim. An incident actually on 1/1/2008 was, my lord, the informant had some illicit relation with one Shahjahan Ali. And on that day, my lord, public, my lord, get out, and the Shahjahan Ali was confined. That reflects in the forwarding report also, page 16. And Shahjahan Ali was recovered from my house. Page 16. Four. Ground of arrest 4 minus serial number, it is reflect 4 and 5.
What about the CD?
My lord, her statement, although 183, my lord, statement was not there, but her statement before police is there, my lord.
Same. Same. Like FIR.
Like FIR.
How many days?
Well, on 1/1/2026, my lord. Arrest.
Learned counsel for the petitioner noted was an application of it. Page 59. Last part of brief of the case as to detail. Learned counsel for the petitioner submit that the informant was having an illicit relationship with one Shahjahan Ali and was caught by the villagers and were house of the present petitioner. because of which the informant had lost the instant FIR. False allegations against the petitioner. This appears to be a stable case where the victim woman was videographing her alleged rape by the petitioner. Having regard to the above, as well as period of detention undergone by the petitioner, the prayer for bail is allowed. And so shall be released on bail of 20,000 one surety.
Judicial magistrate,
Cooperate with the investigation.
judicial magistrate first class.
Judicial magistrate first class.
Poco. Number one, my lord, pre-arrest bail.
Who is the petitioner?
My Thompson. Accused number 5.
What about accused number 5 in the CD? Anything is there? Regarding recovery of
Otherwise, my lord, I do not find any such. Otherwise, my lord, after videography, my lord, she showed those photographs to the, my lord, public. Thereafter, my
as
lord,
far as accused number 5 is concerned, which this item pertains to, the allegation is he
Taken away
taken away 40,000 golden earring and such other items.
regarding those, my lord, I have not found any such material.
Hard learned counsel for the people. This is an application on 38 hereditary bail. Okay, I got to do it. Yeah, probable case it line. As far as the allegations against the present petitioner is concerned, regarding taking away rupees 40,000, certain other articles. The fine. That's shall be released on with one share the arresting authority in connection with the aforesaid, provided that the citizens shall cooperate with the application.
Obliges.
Twenty-four, my lord, case diary not received, my lord.
My lord, kindly turn to page 9 is the affair, my lord.
How many days?
Well, 22 days, my lord.
Huh?
22 days, my lord. And there is a civil case also pending, my lord. Kindly, my lord, page 9. Actually, my lord, there is a dispute between Bazaar Committee and the informant side, my lord. And we have purchased one plot in that Bazaar, my lord. So, it arose, my lord. One civil case already is pending, my lord. It is reflected, my lord, in the affair also, my lord. Since 2018. As per my instruction, my lord, no such serious injury was caused, my lord.
And the house was burned down.
But that section has not been added, madam.
29 January, CD.
10 to 10,
Ten.
10th of February.
Oh, that will be too long.
Oh, too long, yes, my lord.
29,
29.
30th.
Item 59, my lord. Sam, my lord. Item 59. my lord.
59.
A week, my lord. Interim is there, my lord. That may continue. Obliged. my lord.
CD was called for, your lordship.
My lord.
59 days behind bar, your lordship. Your lordships may kindly come to the FIR at page 13, your lordship.
How many days?
59 days, your lordship.
59.
59.
What is the offense?
Lordship, one offense is your lordship. Under criminal conspiracy 61 to 3083, 3084, 196 and 299. Of these, your lordship, 3084, it's for 7 years, your lordship. নাই দেখা দেখুন 90 days. 90 days.
Counsel for the petitioner. Any specific material?
There are otherwise materials against the accused, but they are running by organized gang of my lord, extortion, how they are involved in. So demanding those.
But it's 59 days now.
15 cases also pending against the accused person. In this case, shown arrested, my lord. On
So they
25.
say they will not be out.
Yes. Yes, sir.
Additional people. An application under the allegation is contained in the FIR is page, okay. 13.
Page 13, your lordship.
That the leaders of Lasit Sena including the present petitioner and other leaders of Morigaon district are involved in extortion, blackmailing, etc. In other various antisocial, anti-religious activities, various times, creating enmity between the state based on caste and religion. As called for has been received. An additional PP submits that there is petitioner. They are also involved in other cases. The present case, they have been shown arrested
On 25/11.
of 25/11, 25. The petition have spent 59 days behind bars from the date of their being shown. The same. Therefore, bail is allowed. Bail of rupees 3,000 to local share. Satisfaction of the concerned Ilaka magistrate. It is further provided that the petitioner shall not indulge in similar activities. Is on bail and to cooperate with them.
Deeply obliged.
But I'm appearing for item number 72, my lord. Last occasion, Lordship has heard this matter at length. I'll briefly recapitulate the facts, my lord, in this case. May I, my lord? My lord, on 17/4/2025, the police apprehended one vehicle, my lord, bearing number AS01MC2851, from where, my lord, they have seized some contrabands. Now, was the allegation, my lord, that another vehicle was following that vehicle, my lord, and that from that vehicle nothing was seized. Now, this petitioner, my lord, was on 21/04/2025. Police officials visited my house, my lord, at about 2:30 or 3 a.m. of the morning, my lord, and they detained me. And thereafter, my lord, I was formally arrested on 21/04/2025 at 11:30 p.m. On the next day, my lord, that is 22/04/2025, 48 notice was served to my relative at 11:30 a.m., my lord. And thereafter, my lord, from the records, we could find that at about 2:30 p.m., my lord, the police officials left the police station for the remand court, my lord. So, our ground is that, my lord, if Lordship calculates the period, my lord, from the detention to the production period, my lord, it comes around 35 hours, my lord. It comes to exactly 35 hours, my lord.
Yes, we have heard you already on that, I think.
Yes, regarding that, my lord, LCR, my lord, I have flag marked those portions of the, my lord, record, my lord, of the IO, my lord. And IO has specifically written note, my lord, when he was arrested, and thereafter, my lord, when he was produced before the trial. And on record in there, my lord, 48, my lord, it seems that, but from the record, my lord, there is something, my lord, yes, rightly, my lord, that on 3:30 p.m. the police had on that day, my lord, went to the residence of the, my lord, accused persons, and thereafter, my lord, although one, my lord, seizure list annexed in the petition, that seizure list, my lord, police has seized, my lord, one vehicle, that is the, my lord, from the brother of the present petitioner. And thereafter, my only contention is that, my lord, although police, my lord, apprehended the accused persons, my lord, on that night, on that day, on at 3:30, my lord, but later on, the accused person was formally arrested at 21/4 at 11 p.m. That is also specifically mentioned there in the, that is also there in the record. And thereafter, on 22/4, my lord, he was produced before the trial court. So during journey, my lord, from Karimganj to Badarpur, my lord, it will Badarpur to Karimganj, it will take, my lord, some time, my lord, about, my lord, 2 hours.
But even excluding that, effective custody is from the night.
Yes.
Isn't it?
In that, as your lordship, may kindly check the record. I have flag marked, my lord, those.
Alright.
We have also flag marked, my lord.
Noted.
My lord, one aspect I'll just clarify, my lord. My learned senior has said that it was recovered from the possession, some vehicle was recovered from the possession of brother. If lordship peruses the page 38 of CS, my lord, there it is clearly written from the possession of present petitioner.
Page 30 of
38 of the CS, my lord. That is, my lord, annexer petition. Yes, my lord, bail application. And CS is charge sheet is annexed at page 36, my lord. 36. And relevant portion, lordship will find page 38, my lord. Page 38, point number 3, my lord. That is about 76, which we are relying to show the period of detention, my lord.
This is from the charge sheet.
Yes, my lord. 38.
All right.
73, my lord.
In item number 73, Lordship may kindly turn to page 29.
73.
This is the earlier rejection order that starts from page 27. And relevant portion I am referring to page 29, Lordship. Paragraph 4. In my first bail application also, we raised that issue, Lordship, regarding that 24 hours issue. Lordship may kindly say page 30, 1, 2, 3, 4, 5, 6 line from bottom of paragraph 4. However, the time at which the accused was produced before the magistrate is not indicated anywhere, and therefore it is not possible for the court in finding that the accused petitioner was produced beyond 24 hours of his detention of his arrest. Now that this petition was moved during investigation, so case diary was not along with us, Lordship. Now case diary is a part of record. We have checked it. In the case diary, there is an entry, Lordship, that this present petitioner was left for from the PS at 3 p.m. on 18th. There is an entry of that in the case diary, Lordship. 3 p.m. on 18th. So even if we exclude that duration, Lordship, of time, Lordship, to travel to the court, and we take that 3 PM is the time when he was produced before the magistrate. Even then, it will be Lordship more than 24 hours. So that entry is there, that I have flag mark, Lordship. Pink color flag mark is there. So regarding that petitioner, Suman Uddin.
Mother, one small prayer, Mother. In item number 72, we have filed an IA, Mother, for correct address. We have brought the correct address through this IA. So that may be treated as a part of the bail application, Mother. That much prayer, Mother. Deeply obliged, Mother.
Obliged.
Item 74.
In this case, you'll also scan copy of the PCR was called for. 74 CD not received.
Scan copy, I think.
Scan copy.
Scan copy of PCR not received, list again on.
Obliged.
Make please your lord.
Mother, here CD not received, my lord. Then interim, my lord.
They did not receive. Can also interim to continue till next date.
CD, my lord. 19th, my lord. 19/2.
Received.
My lord. My lord. Yeah, up to date CD not received, my lord. Up to date CD and FSL report now.
Today's CD along with official report as called for has not been received. To reminder list again on so and so interim order passed earlier.
My lord. 19, my lord. 19/2. Similar prayer, my lord. Up to date CD and statement of the victim not received, my lord.
Right, same order.
19, my lord.
My lord, there was a interim prayer that may continue. Item
That
30.
is continue. Continue.
Oh, photo that below.
19. 19/2.
May I please, Your Lordship? Lordship, last occasion, TCR and case diary was called for, my lord.
32, 33, 34. So
30, same, my lord. FIR is at page 15, my lord. This is a, my lord, FIR arising out of an, my lord, dispute, my lord, conformment between the villagers, my lord. There, which is arising out of an, my lord, Gaon Panchayat, my lord, election. My lord, kindly peruse the FIR at page 15. May I read, my lord?
Yes.
Here, my lord, the সন্মানপূৰ্বক বিধিত নিবেদন এই যে যোৱা ইংৰাজী 19/7/2005 তাৰিখে নিশা প্ৰায় 11 মান বজাত উপৰোক্ত আটাইকেইজন পদকীয়াই মোৰ ঘৰত আহি মোৰ মাজু ল'ৰা শ্ৰী গিৰিন গোস্বামী লগত কিবা কথা থকা বুলি ঘৰৰ ভিতৰৰ পৰা মাতি লৈ যায় আৰু তাৰ ঘৰত পদূলি মুখত আটাইকেইজনে আগুচি লৈ মোৰ পুত্ৰক শ্ৰী গিৰিন গোস্বামী গুৰুলা গুৰিলিকৈ প্ৰহাৰ কৰি জখম কৰাৰ উপৰিও পদকীয়া কেইজনৰ মাজেৰে কেইজনমান ব্যক্তিয়ে চোকা অস্ত্ৰৰে আক্ৰমণ কৰাৰ শৰীৰৰ বিভিন্ন
Any injury report is there?
my lord. I have check mark, my lord.
My lord, here, my lord, the Girin's on, my lord, page 22.
Hey, scan copy do. Scan copy do.
So my son's, my lord, son's sister-in-law was defeated in the Panchayat election. My lord, therefore, he has sent some abusive messages to the Facebook. And who has been elected, my lord, their supporter has been objected this messages, my lord.
Injury reports are there.
Confrontation between the my lord, both parties, my lord. There are injury from both sides.
Injury report is still not available.
Final report, my lord, regarding the green Goswami murder.
There of injury can be determined after investigation. Investigation means, I think, for the head injury. Can and all is not there.
Moment, page 22 of my petition, kindly peruse, my lord. Team has some uses some language, my lord, which is
They are on interim.
yes, my lord. Statement has been already recorded, my lord. Anyways, they have to face the trial, my lord. Statement has been recorded, my lord, after the.
Charge is not yet framed, my lord. Only transferred the matter to JMFC. Receiving the charge.
Because my lord, victim sister-in-law was defeated in the election, my lord, the dispute has been arises, my lord, between the villagers. They belong to the same village, my lord. The accused and the victims. My lord, victim has uses some of the languages in the Facebook messages, my lord, which was not tolerated by the my lord, the supporter of the.
Learned counsel for the petitioner. Learned additional KP. Along with scan copy of the here has been received along with this application of PNSS, the petitioners. It 25 of paragraph. In the FIR that an operation took place between the side and the side regarding a post in a the Facebook account of the petitioner. Trusting certain persons. The got elected as a GP president. Because of which an altercation is such course of the and others assaulted the son of the informant, causing grievous injuries. There are and others also.
My lord, others,
And others,
family members, my lord.
other family members. Causing the result of the medical does not feel any external injury. Although the allegation is that they were repeatedly assaulted by bamboo sticks. But to the fact that having regard to the fact that the investigation of the case is over. Also the report. Detention of the petition. Dated
My lord, 27/8/2025.
hereby made absolute. The petitioner self. The trial, if one comment shall not try to intimidate the witnesses. Stands disposed.
33 and 34 are same, my lord. Arising out of
34, same order.
Same, disposal.
Deeply obliged. my lord.
My pleasure, Lordship. Yes, I'm praying for time being, my Lordship. Your counsel, Mr. Asa, is on leg, my Lord.
The number 36. 35.
Deeply obliged, my Lord.
It is received.
My lord, here CD not received, my lord.
They did not receive
Madam.
interim order passed earlier to continue till next date of receipt. Please take it on.
My lord. On border for my lord, 20, my lord, 20.
Lordship. FIR at page 10, your lordship. Here in this case, the operation took place on one hotel. That hotel name is Pancharatna. And as per the CCTV footage, 4 accused person was arrested along with the 2 girls doing the illegal immoral traffic works. Whereby, Your Honor, one hotel person, Pancharatna hotel manager, Majidul Islam, is the person at that 11 point of time, whereby conducting all the business. Now, I am the owner of this hotel, Your Lordship, and accordingly, Your Lordship, this way, no way connected in this case. Page at Your Lordship 10. Page 10, Your Lordship. FIR. May I read, Your Lordship? Page at 10, Your Lordship. And thereafter, Your Lordship,
that two girls who are supposed to be apprehended, then they have police has.
His
left-
second application.
Yes, sir. This is a first application after rejecting in the lower court.
In the earlier rejected court below, my lord.
Court below your
After
lordship.
going to the material.
Materials on the record, then it is found. My case is hand in your lordship. It is in no way connected, your lordship. And mere statement of the victim cannot be treated as I am the owner of the Ponsaratna hotel. I am nothing with
Why
business.
before me specifically? Yes.
That
So
two,
to involve POXO matters also.
lordship, in this case, two girls, if lordship permit me to mention one stand on it, it has been learned that one at hotel Masjidul Islam has with criminal intention splitting so and so has been running with business so and so. That learned cannot be effective for as a owner of my business. You know. So I am the owner, completely owner, and I am doing lots of business. At that 11 point of time, I was no way connected. I have been paid the salary to my manager. And as per the CCTV footage, everything is done in the naked eye also. Is there any involvement at that 11 point of time, then it is a defined issue, your lordship. Mere presumption on my as a landlord or as a hotel owner. And interestingly, your lordship, in that 11 point of time, the two girls were left out. The police has apprehended all the accused person and left the two girls. And later on, they take the interrogation and make the statement that these other persons have been involved in this. So my humble submission is that maybe if search has been not framed, your lordship, trial has been search sheet has been filed, I may be considered, your lordship. Otherwise, I cannot do my business in. If anybody person come in my hotel and doing this type of allegations, then I can stop my business. Where I invest a huge of property, huge of investment is there, your lordship.
Yes, what is there against the owner?
My lord, lordship may kindly produce the I have flagged my lord, two statements, my lord, and his involvement. As per supervision and direction of the my lord, owner, my lord, it was done, my lord.
Supervision and direction at that 11 point of time, if it is an involvement, then I may be disqualified otherwise, your lordship. But in this case in hand, a mere statement, mere assumption, that cannot be done, your lordship. I am at my own native place, that 11 point of time. Really innocent, your lordship, in this case.
How many days in custody?
Your Lordship, I am in anticipatory.
Anticipated, he is not cooperating during the investigation, my lord.
Lordship, last
And
occasion-
he is the owner, my lord, from the statement of the and other co-accused. One, my lord, Bilal Hussain, he is taken both the girls, my lord, two victims, my lord, taken to the girls to the hotel, my lord, and thereafter that incident happened, my lord. Several persons came and go, my lord, and committed the offences, my lord, in the hotel, my lord. In the statement of the manager, my lord, hotel manager, my lord, and other Bilal, both of them implicated the present petitioner, my lord. He is the owner of the, my lord, hotel. As per supervision it was done, my lord.
Lordship,
Materials are there.
Bilal Hussain is there, Majid Al Hussain is there. Where is the question of your Lordship hotel owner? Bilal is the taken the persons to the girls. Majid Hussain is the manager of that 11 point of time. I am staying in my native place. Mere supervision cannot be there. Cannot be a ground, your Lordship. If it is there, then let me go to the. I will face the trial if it is there for presumption in that case. But here in this case, I am totally. I having no any other alternative. I approach before this honorable court.
And victims are taken in the pretext of giving some job, my lord, in the my lord. And thereafter she was brought to the hotel, my lord.
Then jobs also, everything is done by my manager, your Lordship. My involvement is totally involvement in this case. I may be protected, your Lordship. At any condition, I will be cooperate before this honorable court or investigation agency.
What is the interim order?
No, not interim. order, not
nothing
there.
else.
No interim.
No interim.
No interim.
Could directly call for the TCR and.
On the last occasion, only charge sheet submitted, my lord. Thereafter, no, in the last occasion, we have submitted the report, my lord, regarding charge sheet, my lord. Thereafter, Lordship was pleased to call for a scan copy, my lord.
Without interim order, Lordship. Directly call for the TCR, your Lordship.
Okay, we'll see.
I am deeply obliged, Lordship.
CD was called for.
Received.
Rahul.
Yes, my lord, offence alleged to have been under section 351 subclause 2, 352, 353 subclause 3, 356, 324, 115 of BNS, my lord, except 355, 353 subclause 3, all other sections are bailable in nature. My lord, kindly peruse the FIR
Yes.
at page number 12, the type copy, my lord. Most respectfully, I beg to inform you that since I have been working as a chowkidar in Panitanki under L&T company situated at Durbasagar for the past few years, my neighbors, namely Mukesh Thapa, Rahul Das, has been attempting to consume liquid inside the Panitanki. As I have been looking after the Panitanki, as said, I have obstructed them from entering inside yesterday night. They attempt to enter inside the pani tanki to consume liquor, but I obstructed them. The said two boys, along with their friends, came to my house at about 3:30 a.m. and knocked the door and asked to open the door. Thereafter, when the door was opened, all of them entered into the house and hit me with bricks in my foot. They also assaulted my wife and 12 years old son. Due to assault, I sustained grievous injury on my foot.
Anything is there injury?
Yes, injury report I have received, my lord.
What is the injury?
Injury, my lord, nature of injury, the injury is simple and fresh in nature and caused by blunt object. Only because, my lord, he has not allowed them to drink, my lord, at the campus, my lord. So that, my lord, these accused persons were assaulted.
The course of investigation, one of the accused person was arrested, my lord, and he was enlarged bail on the day of production itself, Annexure B, page number 19. But the learned court below has observed that perusal of the FIR reveals that no case under section 353 subclause 3 has been made out, my lord. Annexure B, page number 19. And your lordship,
Dated 17/9. CD call for has been revealed, received along with it,
same order, what
which
you said.
reveals only simple injuries having regard to the care of the allegations. Report the therefore pre-arrest bail is allowed. Order of interim pre-arrest bail dated 7/9/25 is hereby made absolute on the same terms and conditions. This first of.
Update, my lord, case diary not received. Up to date case diary.
Up to date CD not received.
Petitioner is
List again
continuing.
on so and so interim order passed earlier to continue next date.
19-2.
May it please, lordship. This matter, lordship, FR has been filed. Lordship, final report has been filed.
This submitted that final report has been submitted in the instant case.
My lord,
What?
one case has been registered against the present petitioner, my lord.
Yes, registered, lordship.
Gormore PS case number 49/20.
All right, he says final report has been filed, so where
Final
should we
report is not.
retain? Final report has been submitted, hence the petition has become infructuous.
Regarding that, my lord, I have no instruction.
Accordingly, it stands closed.
This
So it is his risk, not yours.
Final report December. Oh, okay. M40, my lord, updated CD not received.
That CD not received. List again on so and so interim order passed earlier to continue till the date. Oh.
May I please, lordship? My lord, the petitioner before your lordship is a lady, my lord. And she was granted interim bail, my lord, and CD was called for. My information is that,
In
my
this
lord,
case, my lord, search sheet submitted, my lord.
the matter of, my lord, old matter, my lord, newly FIR was lodged, my lord, page 15, my lord.
Search sheet submitted on 5/10/25.
Admittedly, my lord, it was a scheme of 2023-24, my lord, and the FIR was came to be filed, my lord, on, my lord, 29/7/2025, my lord, and it specifically, my lord, taken plea, my lord. In the meantime, she was actually, my lord, already retired from her office, my lord. He was elected president of the concerned panchayat, my lord.
So his statement was recorded already. Interim was granted.
Yes, interim granted, but CD is not available. Only I have got the instruction regarding filing of charge sheet, man. So whether it's still
Perhaps
recorded or
my
not.
lord, before my lord approaching, before this honorable court, my lord, charge sheet was submitted, my lord. Immediately just before, my lord.
Charge sheet submitted
Because,
on
my lord,
5/10/25, man.
earlier order, my lord, it was
Interim granted on 24/10/25. The abscond granted.
her bail was rejected by the learned. Her bail was once, my lord, declined by the learned session judge, my lord. She was never been absconding, my lord. She was an old lady, my lord. Suffering
Old.
from various ailment also, my lord. Her medical prescription is, my lord, NHR 3, page 22 onwards, my lord. Due to grant, my lord, recently concluded panchayat election, my lord, this lady,
Order dated 24/10/25 বলে যাব। By order dated 10/25, interim granted by this court petitioner. Having regard the stand of that the works were executed with the funds allocated by the 15th Finance Commission after completion the tenure of the petitioner. That the chart prior to passing of the interim order dated 24/10/25, the sheet had already been submitted on 05/10/2020. Regard to the fact that and also to the nature of the allegations. In fact, that the petitioner is suffering from various ailments, it would not be necessary to confine her for the purpose of the trial. The prayer for pre-arrest bail is allowed. Order of interim pre-arrest dated 24 is hereby absolute. It is further provided that the petitioner shall trial if one commences.
developments.
May I please, Lordship? Lordship, FIR page 10, Lordship. That the present petitioner is the accused number 4, Lordship. She is the lady of 49 years, Lordship. This honorable court granted the interim bail, Lordship. She was appeared before the IO, and the IO also recorded her statement, Lordship. Thereafter, Lordship, without sending the case diary, Lordship, the IO submitted the charge sheet before the learned trial court, Lordship. Lordship, allegation is, Lordship, kindly come page 10, Lordship. FIR, Lordship. That page, next page 11, Lordship, allegation is only against the accused number 1, Lordship. Vikram Gill. She is the son of the present accused, Lordship. Present petitioner is not petitioner is not present at the time of occurrence, Lordship. Neither she was present, neither she entered any dispute, Lordship. The dispute relates to the love relation between the informant sister son and the daughter of the petitioner, Lordship. That is the mainly dispute, Lordship. Petitioner and her family member is not interested to give the marriage of their daughter with the informant sister son, Lordship.
Yes, PP.
There in the injury part, that is grievous, but he's became all alone also.
He is a relative of 14 years, Lordship.
Yes, yes, yes.
Two minor son is also reading in class 7 and 4, Lordship.
So this grievous injury is caused by whom?
First, accused number 1, Lordship. In the FIR, page 11, Lordship, it was mentioned, Lordship.
What is the name of accused number 1?
Vikram Gill, Lordship.
Against the present petitioner, there is no such allegation.
Direct.
Order dated. If the allegation against the reflected in the fire. The accused persons are others. They have been harassed. Government and her team members attacked the informant, sharp weapons. The specific allegation is against number 1. That is Vikram Gill. However, the present petitioner Gill is the mother.
Mother,
Mother of the is number 1, and there is real against her. Yes, injury. To the above, the prayer for pre-arrest bail is allowed. The order of pre-arrest bail dated 30/10/25 is hereby made absolute. Order provided the charge sheet has been submitted. The petitioner shall trial if one commences against her.
Highly obliged.
44 Lordship, TCR was called for, that is not placebo.
Lordship. Lordship, may I pray for interim prayer? If what happened in this particular case, my Lordship, earlier your Lordship 3-4 times called for the case diary. The IO did not produce the case diary. Thereafter, my Lordship, the charge sheet was filed, my Lordship. And in the meantime, my Lordship, the accused number 1, the main accused, the husband of the present petitioner, my Lord, he got the statutory bail, my Lordship. In the meantime, substantial time has been elapsed, my Lordship. So she being a lady, my Lordship, may grant her the interim bail. If something incriminating in the charge sheet, the Lordship may
I
cancel the
think
bail.
you were supposed to file an additional affidavit.
Lordship, today itself, I'm going to file. I have already.
Then
103 is the Lordship.
just to have come up with this, then why did you wait till today to file it?
Lordship, day before yesterday, my Lordship, I got the charge sheet and the.
And copy of PCR is not yet received. Additional affidavit has also not been filed by the petitioner. Submitted that the same will be filed to the matter along with the additional affidavit. On
Lordship, may I pray for shorter date, my Lordship, may I sit.
the short date.
Second.
Deeply obliged, my Lord.
Initially FIR was not registered, CD later on FIR, I got the CD, case registered regarding the present case. So prima facie it seems a civil dispute. Your Lordship may kindly peruse the FIR, for the purpose of that inquiry.
Okay. Or four. Yes, call for has been received. Learned additional people. Clearly submits that the it appears to be of a civil nature. But to the prayer for pre-arrest bail is pre-arrest bail dated 14/11/2025 is hereby made absolute. Hence disposed of accordingly. And absolute of the same conditions. Send back the CD.
That is Lordship.
Did you receive, my lord? Is that petitioner is in interim, my lord. This statement, he appeared statement recorded. Whereas, my lord, petitioner here allegation against the petitioner accused person is that, my lord, here the present petitioner is he is the business partner of the informant, my lord. They are dealing in, my lord, business of coal mining and trading.
The heard counsel for the petitioner. Dated 14/11/25. Paragraph 3. Case called for has been received. If granted interim pre-arrest bail, having regard to the fact that the FIR was lodged long after the alleged occurrence, fact that the dispute, prima facie, civil nature. Pursuant to the aforesaid order has appeared before the, and his statement has also been recorded. Where to the above, the custodial interrogation of the petitioner considered next. Therefore, pre-arrest bail is the order of interim pre-arrest bail did hereby meant absolute. Petition stands this way.
Highly obliged, Lordship.
He may not charge sheet submitted in this case. Charge sheet submitted.
Praying for a short time. My lord, as my senior is on legs in another court.
Prayer of learned counsel, please again on the past earlier to continue. Finally, he was, our seat has already been.
The 53 CD not received, my petitioner is in interim.
List again on so and so interim order. Continue till next date.
23 to.
May I please vote?
Petition from earlier rejected by your lordship, my lord, and no new ground, my lord. The paid currency, my lord, there are sufficient materials again, right?
It was rejected by this court 2/12/2025.
Yes.
That's it. Nothing was recovered from my possession, Lord. The accused Mujibur Rahman was arrested and he was released on
What is his involvement? There was some involvement, that is why it was rejected.
He has not cited any new grounds in his petition.
But his involvement is there.
There, man. Although from his position, my lord, those fake currency note were no, he is a associate, my close associates of my lord, that my lord Mujibur Rahman, and my lord, he now submits that Mujibur Rahman already granted bail. My lord, that bail order, my lord, whether default bail or my lord for other reasons, that is. That was it.
1225. This call for has been received. The result of the case diary learned that there is.
And my lord, against him, against Baharuddin, my lord, other cases also, my lord, the Samuguri PS case number 166 oblique 2000.
Against the petitioner showing him as a closest main accused has already been arrested. Where it is further submitted by an additional PP that the petitioner. 789. Dismissed.
Heavy swell of him.
Your 482 application, Lordship, for granting anticipatory bail, Lordship. That FIR, your Lordship will find page 14.
My lord, before
Page
starting
30.
my colleague, my lord, I have submission, my lord, I have submitted that co-accused bill petition already rejected by the cordial bench of this court. Justice P. Das, my lord, and then it will. First, it will in that present case also go to that.
So as per new notification, Lordship, if that bench is available, then it will go. That notification number is notification number 27 or dated 3rd May 25. If co-accused bail application is rejected and that bench is available, then it will go. That bench is not available this week.
But in the next week, it is available. My lord. Perhaps in the
That
next.
is a different issue, but today that this matter is listed already and fixed by that court. Only. Here, in fact, if your Lordship pages page 15, your Lordship will find that illustrative example of fraud is given. There is no specific allegation that this is the amount defalcated, or these are the amounts collected, or these are the persons from whom it is Lordship fraud has been committed. Lordship. It is not their specific case, page 15. And in the present case, Lordship, the present petitioner is already Lordship suspended and he is not in service, Lordship. So
Where is the rejection order?
My lord, here.
This present petitioner's case is not rejected, Lordship.
Co-accused.
Co-accused.
My lord, here, Lordship, may kindly pay you. In that case, there, my lord. Second, sufficient materials are there. They are using the fake receipt, my lord. They have collected huge amount, my lord, from different person, my lord. Their statements are also available. My lord.
Yes.
Present petitioner is junior assistant lordship and he is not the tax collector of that municipality.
But it duty was given of them, my lord, for collection of the tax, my lord, from their office, my lord.
It is sufficient material against you as well,
Minor.
similar to the. Parity will be applicable in case of rejection also.
But
Both of
lordship
them
may
are
kindly-
same footing, my lord.
that he is already suspended from service and all are documentary evidence. If any receipts are found, that can be found, lordship. Their
No,
custodian.
all need not necessarily be, because allegation is collecting and depositing lesser amount.
My lord, my lord,
What is the collection?
my lord.
That may not be in documents.
But it will reveal from the receipts, lordship, which are the big, in the custody of the municipality, lordship. Because they submits the report for after collecting all the taxes, lordship. Because they have to submit those receipts. And there is entries there that regarding how many houses are there, how many shops are there.
Question is how much is collected and how much is shown in the receipt.
My lord.
That as per page 15, it is 18,836. Illustrative example.
This is also said in this regard, my lord. They have collected
Collected more.
that amount, my lord, but it was deposited lesser amount in the office.
For that, lordship, they already lost their job, lordship. That part, lordship, may kindly
That part is
consider.
defined, my lord, but here the criminal part is defined.
Because everything from the office has been seized by police, probably, lordship.
You are working as?
Junior assistant,
Junior
lordship.
assistant.
Same
lordship.
category,
Same.
same.
Right. Heard, Mr. Shanks. Nineteen. Five. Plus. CD there. 3, 4, 5. Seven. The fact that the co-accused also been rejected, who stands on a similar footing, has also been rejected by order dated 19/12/25 in AB 2925 of 2020. The For pre-arrest bail stands rejected. Send back the seat.
Oblige, Lordship.
My lord, as per information, my lord, charge sheet submitted.
Questions payable na কি?
109 access center.
Your interim is there in both the matters, my lord.
Interim access? Okay.
180920. 180920.
अपने से नहीं था।
Yes.
My lord, here charge sheet submitted, my lord. I have received the information. My lord, the file charge sheet number 401 of 25, dated 29/11/25.
Allegation is what? Attempt.
My lord, 109 is there, my lord.
But basically, my lord, this alleged victim, he fell down from a bridge. Under what circumstances he fell down, my lord, that is disputed.
But allegation is there, my lord, 109, my lord, that is.
Then let's call for the TCR. Submitted that charge sheet has already been
So, my lord,
submitted.
since interim is there, my lord, they will appear before the regular court, my lord. Interim may be extended
Till then,
till then.
submitted, charge sheet submitted by so and so. Submitted that the petitioner appear before the learned court below. Present petition is disposed of. Observation that the petition appear before the learned court in a period of
15 days, my lord.
is from till then the order of interim pre-arrest bail dated 18/9/25 shall continue to remain in force. Disposed of accordingly.
Okay. Yeah, please.
Look at 76. No,
My lord, 75, 76, my lord. Oh, 75, 76, both.
preparing for both.
My lord, same FIR.
May I please, the Lordship? My lord, this is a pre-arrest bail application, my lord. My lord, I have filed an additional affidavit to bring on record the corrected translated copy of FIR, my lord. Earlier, my lord, there is some mistake and it is in record, my lord. And now I have filed, my lord, an additional affidavit. It starts from page number 62, my lord. From the FIR itself, my lord, and on the last occasion, Lordship intends to give us the interim protection as the civil dispute is between the two parties, my lord. As I have done a mistake in my translated copy, so therefore the CD has been called for, my lord.
Very civil.
My lord, here in the two accused persons are arrested, my lord, they are released on bail, my lord. Yeah, in the FIR, my lord, accused number 14 and 15. They have been arrested, my lord. I'll kindly produce the FIR.
Where is that?
FIR is page 62, my lord. Corrected translated copy in my additional affidavit, my lord.
62.
My lord. Start from 62, my lord. May I read, my lord? My lord, here the schedule has been mentioned that, my lord, and civil dispute is going on between the parties. And I have annexed a copy of injunction order in my bail application, my lord, page number 46, my lord. Relevant portion, my lord.
Yes, PP. Injuries are simple.
Lordship, previous.
Report says simple.
No, sir, there are several reports are there, Lordship. 2-3 reports are also there, Lordship. Previous, Lordship. First is the simple, there are some other persons injured, Lordship. This has also implicated them, eyewitnesses also implicated them, Lordship. Because of the civil, as a civil dispute is going on, civil cases are pending, that cannot be plea for taking bail, Lordship. Several persons are injured. Persons are badly.
May I submit, my lord?
Yes.
My lord, the FIR was lost on 16/11/2025. My lord, already, my lord, 2 months has been lapsed, my lord. Most of the part of the investigation has been completed, my lord. Now the custody of the present petitioner with the required, my lord, as I have submitted and from the record itself, my lord, that the schedule they have mentioned in the FIR, my lord, that it is their possession. But from the injunction order itself, it is revealed that this land is in our possession. So a dispute has been arises between the two parties. And in this regard, 2 persons has been arrested, my lord, and they have already released on bail, my lord. Accused number, my lord, 14.
2 persons, we don't know their role. Why they have been released. For whom? Hussein Bolbhuiyan.
My lord. They all are the, like, Altaf Hussain Borbuya, it is a plaintiff, my lord, and the other are pro forma defendant in the civil suit, my lord. And the informant husband is an main defendant in the suit, my lord. They all are the family members, my lord. The petitioner before your lordship.
Family members.
Yes, you have something to add.
Yes, my lord. I am for the informant, my lord, and to assist my. Yes, injuries were caused, my lord. Taking the plea that the civil, that does not mean they are empowered to do as they like. They entered into my house, set fire also, by causing these injuries. Fire in the house, they corrected FIR, the last person it is sitting there, my lord. The last time they avoided that portion. So by filing the affidavit, they corrected the FIR. That fire in the house also.
Okay. First.
In this matter, my lord, on the last occasion in the other court, my lord, it was verbally decided that it should go to the division bench, but as the connected what High Court rule is bad. So already matter is under process, new rules are coming within next week, my lord. That similar case to be taken by the division bench. So my lord, maybe list after 1 week only, my lord. I have gone to the registry and discussed the matter.
66 and 67.
Seven.
The prayer of learned counsel for the is the matter. In on
My lord, fixed on second week, my lord.
date in the second week.
On a hearing table. No bless.
মই এটা সৰু submission এটা কৰি দিছো। Case number 2. This has come for admission, my lord, and I have a small prayer. So far, with regard to this is with regard to final report, with regard to challenging for registration of a case under 156(3) was negated by the trial court against which they have come in. Now there is another case filed by the same parties, and that's been registered as criminal petition number 1189 of 2025, my lord, and that is also been pending. And so this will be very important because some advertisement has been made in this particular petition with regard to certain facts. But altogether, a different statement has been made in that particular criminal petition. Apart from that, there has been a development in here in this case, wherein we have come across additional documents wherein this matter is being subjected to Enforcement Directorate investigations. So in that case also, after investigation also, offense report has been submitted and it is pending in the court of special judge for precognizance hearing. So this matter has to be brought before this honorable court for adjudicating the whole matter. This is my respectful submission. Otherwise, the case has come for admission, my lord. Let the pleadings be completed and thereafter it will be finally disposed of, my lord. Both the matters together.
My lord, it is my petition, let me place it. My learned friend is an OP. Let him take his seat, my lord.
That cannot be, my lord.
Yes,
How
that can be.
It is my
Because, my lord, the
I
more
can
it is
make it,
delayed, they stand to gain. But I'll show, my lord, that holier than thou attitude of the client whom my learned friend represents. What they have done, my lord, in effect, they have evaded income tax to the extent of 21 crore. By showing a loss of 59 crore, how advantage has been taken, how, my lord, false statement have been made. They have shown that they procured school bags, uniform from XYZ, and they are not persons dealing with those particular items. And below the status report supports our case. And kindly see, my lord, on what basis our case has been rejected.
Status report, sir.
Kindly see, my lord. On last two occasions also they have taken time. Yes. My lord will kindly come take my petition, my lord, 761 of
I
25.
leave to the wisdom of this court. If
Yes,
this honorable court wants to hear it, my lord, let it be heard, my lord, giving an opportunity to us to file additional.
My lord, heaven is not going to fall, my lord. All that will happen is a case will be registered if our petition is allowed and it will be subject to an investigation. That's all.
My lord,
As such, a case. Why are you shying away? If you have got nothing to hide, then please take your seat. Unnecessarily, why are you praying? It is my petition. Let me start.
my lord, my prayer is very reasonable. My lord will hear it, my lord, wherein the pleadings are not completed with regard to records. We have to bring on record.
My
And
lord, it's
even
a
then,
criminal case.
even
What is
then-
the requirement of a record? It is not a
that
certiorari
will
proceeding.
not be decided by the petitioner, my lord. That is the prerogative of which we have been made a party by a honorable court's order. And we have a right to audience and place it all the facts before this honorable court without the half truth.
No, anyway, my lord, lordship will hear my perspective. Thereafter, if your lordship feels it's a case where lordship should grant them time, then I'll leave it to your lordship's wisdom, my lord. There also I don't have anything.
That
to
is
say.
okay.
Let me place my facts.
My lord.
Every time before I stand up, you stand up. That's the difficulty I'm facing. Please come to my lord the petition, my lord. Now, what had happened, my lord? Earlier, there was an FIR lodged by his client alleging they have been, my lord, cheated by some personnel of Motok Autonomous Council.
Now kindly see there, my lord, conduct. They expect that they will make supply orders to public authorities without tender. At the same time, they maintain an allegation that they have been cheated. Now, if we speak of morality, then such people should be cheated. Illegally, that is otherwise, my lord. Now, what had happened, their case is, they have supplied school bags,
So blankets.
blankets and mosquito nets to my lord, Motok Autonomous Council. And they say they have made supplies worth 59 crores and they have not been made any payment. Therefore, they have incurred loss. That case is going against us, my lord. Our clients were behind the bar for almost 1 year. Kindly see the, my lord, irony, my lord. Now, it so turned out that the person from whom they have said that they have procured blankets, school uniforms, and mosquito nets, they do not even deal in those products. They do not have an GST, registration, my lord. Now, please come to my affidavit in reply, my lord. I'll show 2 pages that will make the position clear. The affidavit in reply starts at page 211, my lord. If your lordship will kindly come to page number 253. They claim, my lord, that these school bags were purchased from this entity. Page 253.
A.
Page 253, my lord. Annexure A of the affidavit in reply. Now, school bags sample approved on 22/10/22 by respondent in as per the allegation in the FIR. The samples were approved on 22nd of October 2022, whereas my lord, purchase was done on 13/10. Kindly see, my lord. The allegation in the FIR is the samples which they supplied was approved on 22nd of October, whereas the purchase was done prior to that on 13/10. And my lord will kindly next come to page number 256. L1, L3 farm, school bags, first purchase done on 1/10/22. Whereas, as I have already indicated, my lord, samples were approved on 22/10. Then my lord will kindly come to page number 259. On the left-hand side top, my lord will see Amit Adnani HUF. This is the vendor of the informants, my lord. Now, GSTN suspended. GSTN suspended. Now, what is the game they have played? That is very interesting, my lord. That your lordships will get at page number 288. This page will make the position very clear. Lord, I have explained in detail. I'll hand over a copy of my written argument, my lord. I'm briefly indicating the bullet points. Kindly see, my lord, this is their accounts. Unless otherwise specified, all monetary values are in thousands. For the period, my lord, 1/4/2023 to 31/3/2023, if your lordship kindly comes to total revenue, it is 107.96 lakhs crores. 107 crore. Then down below, if your lordship comes to, there are one CSR expenditure, that is 0. Then comes other expense, that is the extent of 59 crore they have shown as loss, which they show. They have shown that they have supplied to the extent of 59 crore. Because they have not received the corresponding bill for the goods supplied, so they have shown as loss. Then, my lord, total expenses so and so. Now, if these figures are to be accepted, my lord, they have defrauded, my lord, income tax to the extent of 21 crore. This is their game. This FIR which they have filed, for which we were behind the bar for quite some time, my lord, is only to overcome their income tax oaths. Look, this is a huge fraud. It is a fraud of such an extent, my lord, that it cannot be explained in few words. Now the game is, now they say they have purchased the goods from XYZ. Now, my lord, a status report has been filed. If your lordships will kindly see, I understand my landed friend has taken a copy with the permission of the court. Yes. Now, status report which has been filed. Now, please come to me, lord, page number 6. Para 10, my lord, at page 6. During the course of
Wait,
investigation.
just a moment, let me locate it.
My lord, it is dated 7/1/26, my lord. It is addressed to the public prosecutor, Guwahati High Court.
नहीं आते कोर्ट मास्टर এটা তো স্ট্যাটাস রিপোর্ট বলি এখন সে স্ট্যাটাস রিপোর্ট কোর্ট স্ট্যাটাস রিপোর্ট just the forwarding letter dated
Yes,
8/1/26.
7/1/26, my lord.
Here we have 8/1/26.
The report is dated 6/1. It was forwarded on 7/1. I think they received on 8/1, na?
Says Office of Chief Judicial Magistrate 8/1/26.
No, my lord, no, my lord.
From Chief Judicial Magistrate to Deputy Registrar.
তুমি দিনই দেখে তুমি হোল্ডিং এখন এইটো senior special superintendent of police.
They have the copy, my lord. They have obtained the copy most probably from the permission of the court. Let a copy be furnished to us also.
No, you'll get it.
We don't have the copy.
Anyway, my lord, the lordship will take a call on it.
What a copy there.
Even I don't have a copy.
নিদিয়া কিয় এইটো ইফালে টানে ইফালে এই কোৰ্টে চাব বিচাৰিছে সেইকাৰণে দিব কৈছো নহ'লে মোৰ কপি থাকিলে দিয়ে দিলোহেঁতেন
If you are taking the court through that status report, I obviously need to have a copy before me.
Yes, ma'am. Please come to page 6, my lord. Para 10. Page 6, para 10. During the course of investigation, I have asked persons Sri Kamal Sabharwal, Mohit Kaldra, and Rajinder Singh Sharma, the persons whom my learned friend represent, to furnish the following information for the purpose of inquiry of the present complaint. However, they neither furnished the information or documents nor informed any valid reason for inability to produce the document. Agreement made by Sabharwal Trading and associate with respective vendors from where procurement of school bags, mosquito nets, and blankets have been made for supply of same to the Motors Autonomous Council, the one which I was referring to, Miller. Details of the place of business of vendors from where procurement of the school bags, mosquito nets, and blankets have been made for supply of same to the Motor Autonomous Council, Dibrugarh. Now, facts disclosed during course of inquiry. Fact emerges during the course of inquiry is that Motor Autonomous Council never published any advertisement nor made any tender process in respect of works of supply of school bag, mosquito net, and blankets, not to speak of in the name of Sabharwal Trading India Private Limited and Association. The same has been admitted by Sabharwal Trading and Associates, namely Kamal, Mohit, and Rajinder, who are complainant in CIDPS case number so-and-so. Taking into consideration the evidence on record as well as the facts disclosed in the charge sheet of the criminal case registered as CIDPS case number so-and-so, it is found in the inquiry that below noted memorandum of understanding has been made between Sabharwal Trading and Motor Autonomous Council, following which Sabharwal Associates supplied school bags, mosquito nets and blankets worth so and so, so and so. Then Lordship may kindly skip these portions, my lord. Then my lord will kindly come to the next page. A bare para 4. A bare perusal of the tax invoices, vehicle details, ledger book and other documents provided by Sabharwal Trading Private Limited and Associate reveal that Sabharwal Trade India procured the goods from the following entities. So these are the three entities from whom Milord school bags, blanket and mosquito nets were procured allegedly. In course of inquiry to ascertain the facts of allegation averred in the complaint petition, Sabharwal Trading India Private Limited and Associates have been asked to furnish the agreement made by Sabharwal Trading and Associate with the respective vendor from where procurement of the school bags, mosquito nets and blankets have been made for supply of the same to the Motok Autonomous Council, but they could not provide the documents and information. As such, the veracity of facts documents based on which alleged companies Guru Nanak Enterprise, Radhakrishna Enterprise, Markex Branding Solutions have supplied goods to Sabharwal Trading for the purpose of supply of the same to Motok Autonomous Council could not be established and raise suspect of the supply of the goods at such juncture. In course of inquiry, Sabharwal Trading India and Associates, namely Kamal Sabharwal, Mohit Kalra, and Rajinder Sharma have been asked as to whether above companies, namely Guru Nanak Enterprise, Radhakrishna Enterprise, Markex Branding Solutions, were manufacturing companies or not, but they neither provided any satisfactory answer in respect of the said company's firm, nor provided proper details of the. So, my lord, the allegations which we have brought in the petition is supported by the preliminary inquiry of the investigating authority. Well, I'll show, my lord, why these entities do not exist. No. My lord, actually, these are all sale companies. Now, the whole game is to avoid income tax liability. This criminal case has been, my lord, resorted to. No, সিহঁতৰ হেৰি চেৰি নাই যে এইটো কি বুজায় যে 2 নম্বৰ সেইটো ক'লে পাৰে সো এইখিনিটো গোটেইটা সাসপেন্ডেড কৰে ফিলিংস অফ আছে I'm just taking 1 minute, Mila. What is it?
Business. Codes.
Milord will kindly come to page 285, Milord. In tabular form, we have given this information. School bag দিছে না Please come to page 285, Milord. Please come to serial number 2, Amit Adani, one of the LS supplier. He is the, Milord, owner of Guru Nanak Enterprise. He is allegedly L1. GST status active. No firm exists on the place of business. Then second one, Milord, same entity, but of Radhakrishna Enterprise L1, GST status cancel, printing material factory. So, Milord, where is see, look at the difference between printing material and school bags and mosquito nets. Holier than thou. Serial? Then please come to the next one, my lord, Naresh HUF. GST status suspended, cancel, no firm exists on the place of business. এইকেইটা একটু clear তুমি এইটো ক'ব পাৰা নাই। প্ৰথমতে ক'ৰ পৰা? এইটো। My lord will kindly also come to page number 259, my lord. These are the informations which we have collected from the website. Kindly see, my lord, Amit Adani HUF, GSTN suspended. Now, if your lordship kindly comes to the heading down below, dealing in goods and services,
258.
259, my lord. On top left-hand side, lordship will notice Amit Adnani HUF, one of the alleged, my lord, vendor of the complainant in the other case. Now kindly see, my lord, his GSTN registration is suspended. Most importantly, kindly see dealing in goods and services 6305130 jute Hessin bags. So he is supplying school bags. School bags. So he doesn't deal in school bags.
Is jute Hessian bags, bosta.
Yes, sir. Bosta. Next. Then my lord will kindly come to page 261. কি deal করে? Kindly see 261, Naresh, a Hindu HUF, L2 supplier. He is, in fact, GSTN is cancelled on his own. That means he is no longer in business. Now, dealing in goods and services, he deals in copper waste management, scrap, thickness so-and-so, rectangular other of aluminum, alloys, etc. So he is supplying mosquito nets. Tool bags, mosquito nets. Then my lord will kindly come to the next page, my lord, 262. He ki say. MB Sales Corporation, GST suspended. He deals with, my lord, bars and rod, iron and steel.
Mohammed Zakir, next page.
Mohammed Zakir ki say. Then page 263, my lord, is one Mohammed Zakir, RS Engineering, suspended. He deals in, my lord, copper waste. So, my lord, the story as it unfolds, the case which has been registered against us proceeds on the premise that they were cheated by some person who impersonated themselves as representing Motok Autonomous Council. On their part, my lord, their legitimate expectation was they will make supply worth 60 crore to a government department without tender. In the process, they have been cheated. How they have been cheated? Because pursuant to a work order, they have supplied school bag, mosquito nets, blankets. Now, they say they have procured this material from these entities. Now, these entities, we have brought them, my lord, their, what do we call in Assamese is Kusti. Their Kusti is revealed in page 259 and onwards. So, my lord, they have filed a case where behind the bars. Now, I am the chartered accountant of the, my lord, Bansals. Now, my lord, I have also been made accused in the other case, which they have filed. Having noticed all this, my lord, we were shocked. How come we have been implicated? Then we made inquiries. Then you came to know this is the actual state of affair. We filed an FIR, my lord. FIR has not been registered. When it is not registered, then we approached the Learned Magistrate Court. Learned Magistrate Court rejected our petition. That is why we are before your lordships. And kindly have a look at the impugn order, my lord. So my humble submission is, my lord, they should register a case, and it's a cognizable offense. Where is the question of making preliminary inquiry for 10 months? Kindly see, my lord, the order passed by the Chief Judicial Magistrate is at page number 76 of the petition. Also seen the petition filed by learned counsel for the complainant, whereby the learned counsel has submitted one certified copy of report dated 26/5/25, submitted by CID Assam before this court. Perused the same. I have also perused the copy of the petition filed by petitioner Kusdeep Bansal and Harish Bansal before the court of the Honorable Additional Session Judge Kamrup Guwahati in sessions case number so and so submitted by the opposite party. Upon perusal of the said petition, it is evident that sum and substance of the said petition and instant petition number so and so are identical. Further, from the report dated 26/5/25 submitted by IO Dr. Aditya Bordloy, it appears that prior to receipt of the said complaint petition dated 28/3/25, another complaint petition on the same allegation and or matters have been received from one Mamta Bansal, wife of accused Harish Bansal, which was forwarded by DGP Grievance Cell, Assam Police Headquarters, and the same was also entrusted to the IO, while later dated so and so for inquiring into the matter. The IO, being the inquiry officer of the above complaint petition of Punit Agulati, that is the petitioner, and Mamata Bansal, is presently conducting an inquiry to ascertain the authenticity of the complaint, and the inquiry is still going on. Well, my complaint is not going on. What is meant is by the other case. Since the said petition is pending before the Court of Honorable Additional Session Judge, the instant petition is rendered not maintainable and is accordingly dismissed. Now, my lord, this order of the Additional Session Judge, I will place it, my lord. Copy of the Court of India. Lord, this is the certified copy of the order, where the Honorable Additional Session Judge has held to the contrary, my lord. Now, please come to para 24, my lord. This is Mamta Bansal. My lord, this petition was filed by one Partho Bharadwaj. Partho Bharadwaj was the person, my lord, who impersonated as an official belonging to Motok Autonomous Council. Now, in that case, there are findings which supports our case, my lord. That I would like to say, because relying upon this proceeding, the learned Chief Judicial Magistrate, my lord, did not pass any order in our favor. Please come to para 27. If the informant or his company has committed any offense against the petitioner accused person, then petitioner accused person may lodge separate FIR complaint against him. But this case is not the right place to agitate the grievance if any of the petitioner accused person against the informant or his company. This court, being a trial court after filing of the charge sheet, has nothing to do with investigating authority. If the investigating authority is doing further investigation, that part is also not a concern of the trial court. This court is of the considered opinion that trial court is not to direct the investigating authority to further investigate into any matter on the prayer made by the accused person. Accordingly, prayer for further investigation is rejected. Now, my lord, the learned Additional Session Judge was also of the view that if the accused persons have any grievance, then in respect of that, a separate case may be registered. And this is an order of 8th of March 25. 8th of, August. Now, my lord, my humble submission before Lordship is very simple. Now it transpires all throughout we were projected as criminals, my lord. Now, actually, the cat is out of the bag. The modus operandi is something else. This FIR which they have lodged against us, it is the creation of some lawyer in some chamber, my lord. Because if your lordship reads their FIR, it runs into about 35 pages. By reading that FIR, no court will pass any interim order. When they came to me, I said, sorry, no court has time to read this 35. It's all deliberately done. Now it so transpires, my lord. This episode of Motok Autonomous Council having given any work order, secondly, they having made supplies, that they have incurred loss, this all stands, my lord, prima facie to be false. On the contrary, they are guilty of creating, shell companies, making false statement of oath. Look, they are on oath before this honorable court without realizing what they have done. Because when they file the petition, when they file affidavit, they have gone on oath. Now things have transpired that no, basic idea was to avoid payment of income tax. Because in the process of showing a loss of 59 crore in their books of accounts, what they have succeeded in was to not to pay income tax to the extent of 21 crore. Therefore, my humble submission is, my lord, it is a fit case where the CID should register the case and then should proceed with the investigation. They will get that opportunity, my lord. And my lord, I've got few case laws. I don't think it is required, my lord, subject to what my learned friends say. If necessary, I'll place case. Otherwise, my lord, prima facie, there appears to be a case. My lord, in fact, I have prepared a written argument, my lord, which I'll place for your lordship's kind perusal. Entire factual and legal gamut, my lord, I have included in it. At the end of copy of the page number 95. My lord, I'll just show one thing with your lordship's kind permission. If your lordship kindly comes to the FIR at page 96, their FIR, my lord, based on which, my lord, my employer was arrested. Please come to para 6, my lord. This is their own pleaded case. Para 6, page 95. Now their version is para 6. During the month of October, has a lordship's got it, page 95. Towards the bottom of the page, para 6. During the month of October 22, the officials of the complainant company had visited, I'm sorry, Miller.
This in small type. this
Yes,
one.
very small type. That's why I said, Miller, it runs into 35 pages of FIR. I've never seen in my life. I have not done many criminal cases, but the ones I did, I don't find such a long FIR. And if it is really typed into, Miller, with double space, it will run into 100 pages. No? During the month of October, para 6 towards the bottom of the page, officials of the complainant company had visited Guwahati, Assam at different times in order to understand the exact nature of the requirement of products and had also gone to get the sample of the school bags, mosquito nets and blankets approved. Subsequently, after various meetings with Sri Saswat Singh Bundela and one Srimati Pallavi Thakuria, these samples were finally approved. Samples were approved by two sample approval letter dated 22/10/22, which I have shown at Millard, page number, I think 283. Now, Millard Lordship has also seen from the same page, samples were approved on 22, which they now vouch in their FIR, Millard. But Millard, purchases were made on the first week of October itself, before approval. So these are some of the materials to show, Millard, the falsity of their case. And Millard, subject to what my learned friend says, Millard, I reserve my right of it. And Millard, I have brought the judgments in what situation, Millard, second FIR arising out of same transaction can be registered. And naturally, Millard, the perspective of two cases is different. And even if it is, Millard, clubbed also, if our angle is examined, fine. Or they can do it as a cross case. And in the written argument, my lord, we have indicated everything.
Yes.
I stick to my limited prayer, my lord. That with regard to this particular, whatever been submitted before this honorable court, is regard to an affair that has been lodged in CID, being case number 16 of so-and-so, under various sections of law. This has been subjected to a thorough investigation. Now, during investigations, my lord, one Pallavi Thakuria happens to be introducing herself to be an APSC officer. Thereafter, a Motok office was created in Beltola area with Motok, everything, Sam still everything. This has been part of the investigation. These persons were arrested. Many bail application has been preferred many a times. On merit, on perusal of the case diary, it was rejected. After more than 100 days or so, they are ultimately approached the Supreme Court, and Supreme Court have granted bail. Now, in that particular case, charge sheet has been submitted, and list of documents has been there. Now, whether that particular charge sheet or the affair is under challenge, absolutely no. The case has been posted for consideration of charge in the trial court below. So, without challenging the factual matrix in that particular case, they are coming with regard to registration of an affair. Now, so far with regard to this, first they move to the Sessions Court wherein charge sheet has been pending, sir. Charge sheet has been there. Trial has not yet commenced. It is under inquiry stage, wherein framing of charge stage is there. Now, in that particular case, first point of time, they filed a petition for further investigation. That was rejected, my lord. And against that, that criminal revision they have preferred in, that's what I have mentioned, my lord. Both should be treated together because the avertment made here and avertment made there, we can show what is going on actually. That is criminal revision number 1189 of 2025. Kindly note that. Criminal petition. Criminal petition. 1189 2025 challenging the sessions order with regard to, my lord, further investigations. 173A. Now here with regard to challenging the order of the learned magistrate wherein rejecting for registration of a case. These are the two challenges, my lord. Wherein in this order reference has been made to the sessions order also, my lord, and with regard to the prayer being made. So what I am on, that many allegation has been stated with regard to income tax evasion or all such things. That's not the truth. That's the half-truth which is very dangerous. They are standing in the character of an accused and charges are yet to be framed. Now they have come out with all these allegations. They have made complaint in GST also. GST report, Ahilda? Yes.
GST income tax.
GST, they made a complaint before income tax officers. They made before enforcement directorate, my lord. And the income tax department made a thorough investigations with regard to every particular clean sheet. So far GST is concerned, my lord, should investigation complete only. Was it? That investigation is completed, my lord. Clean sheet. Now, it's been projected in that manner before this honorable court. I'm sorry. That what is the GST law with regard to this? That any manufacturer, any trader have to declare only 5 items they are trading with. Maximum 5 can be this. I am trading, suppose 100 metals, not required. And only 5 item is there. And from that, an impression is tried to be imposed upon this honorable court that this is wrong. My lord, this registration, cancellation, and all such things, suspension is there. It is the prerogative of the vendors, my lord. I have nothing to do. Now, when the GST was there, then supply has been made. The truck numbers were there. The material that has been supplied, been received by whom, it has been there. And the enforcement directorate, my lord, made a detailed investigation in this case, wherein offense report has been submitted against these particular accused persons. And even they have, the Assam police couldn't, my lord, with regard to proceeds of crime, they could not find it. Enforcement directorate could find it out. And they have attached these proceeds of crime. Now, sir, when a criminal complaint has been filed against me, suppose, and I have been arrested and I have been charge sheeted, at this stage before framing of charge, I have a right to come to the court by challenging that particular charge sheet and the affair. They have not come. They have trying to put proxies, the CA of that particular account. The accused is not before the court. The CA comes in. I'll take your lordships to what extent one can go. And what are the prayers to registration of a case? On the basis of that particular registration, they will argue that these are all false claims, wherein they have admitted in their petition with regard to making of this, receiving of these materials on record. That I want to bring on record by way of an additional affidavit, my lord, will kindly allow me to do that. They are saying fish is out of the water, fish is still in the water, and it will remain in water only when this records comes in before the court. Half truth will never help this. Income tax report 59 crores, my lord. If I make a supply of 63 crores, 59 crores is become income tax. Under what taxation law?
No, 21 crore.
My lord, whatever it is. So the income tax department, they have made a complaint. What is the result out of it? I will produce it before this court. So now they want to come out from the ED case, my lord, money laundering case, proceeds of crime, and this particular case with the help of this particular registration of an affair. Would it be an added advantage with regard to this? The proper way is regard to this is this. If I am wrongly, my lord, charged or arrested in connection with this case. So for arresting a person illegally, there are provisions in the IPC itself. It itself is a distinct offense. Whether the accused person has come up before this honorable court or the trial court below, absolutely no, silent. Now, if I am wrongly been charge sheeted, even before framing of charge, I have a right provided under the code itself to come up before the challenge the charge sheet, challenge the affair. They have not come. And they want to get a case registered on falsehood, which falsehood would come out from their own avertment made in the criminal petition in the challenging the sessions course order.
But are we here in this forum to determine that?
Absolutely. When the court, a person...
I think the limited question, limited
No, sir.
ground on which it was rejected is that it is identical to the earlier case.
Yes. Yes, because
So we are
the court
required to
has to,
examine that
yes, the
aspect
court,
only.
no, the court has to appreciate to that extent. Because their case is what? They have projected that these are all shell companies. That is the pleadings. Otherwise, the court will not entertain from a third person, a proxy. The accused is not before the court. The charge sheeted person is not before the court. Now to establish that, they are making a statement for which this court, the registration of a case is a serious matter. And that to a third party proxy. And that to a persons who are standing in the character of an accused and been charge sheeted on their behalf. It will be amount to abuse of process of the court. The remedy before this honorable court, there are multiple remedies before the court. Challenging the charge sheet, challenging the affair, they can come. After the charge also they can come. Apart from that, for lodging a false case, it amounts to, my lord, a distinct offense under the Indian Penal Code. A perjury, making false statement in the court of law. What they are saying and trying to project by way of a reply, this one reply call. These are the documents on the basis of which they are paying for, their proxy is paying for investigation, my lord. How he is prejudiced. What locus he has. And my lord will kindly see the verification. not been supported by an affidavit also. Kindly see, my lord, their additional reply. The document that has been taken to this honorable court, this document 259 and all such documents, they have relied on 285, 259, page 95. See this. See this, my lord. These are only statements, my lord, only on the basis of a statement being made without giving an opportunity of being heard to the other side and getting a case registered against me that can influence the pending cases in the court of law would be, sir, injustice to me. That's my respectful submission at this stage. Later on, the documents comes in, an inquiry report has been submitted. We don't have the copy. Let that inquiry report copy be furnished to us. And what is the material and what are the statement made in, and if at all this document I have not submitted, if it's in part of the investigation and it's been part of the prosecution document, if I can show, these are again incorrect statements. So what I am on in this particular affidavit, kindly see, my lord, there is no affidavit on oath a declaration is true. That is not the High Court rules. When you file a reply, when you produce a documentary evidence on the basis of which a case has to be registered against the victim, materials has to be there and been on oath, not on the basis of this affidavit, my lord. This is affidavit, my lord. Nothing else. So may I pray with folded hands before this honorable court. Right to be heard is a fundamental right. So what document I intend to show, and all the submissions been made is been negated by the Enforcement Directorate itself, the Income Tax Department itself, the GST Department itself. In that case, why my lord will entertain a stranger in this case who is not even affected or not standing in the character of an accused? That's my respectful submission, my lord. Additional affidavit will speak in volume with regard to this. And their own avertment in the another case, where they are admitting supply has been made. And here says no supply has been made. Income tax return 21 crores. I want to circle. This is wrong. They say 63 crores supply has been made, but we are not involved. And one of the Bansal brothers is an astrologer. And by astrology, how he introduced himself is the affair and subject matter of the affair on the basis of his charge sheet is pending. So may I pray, my lord has already heard the petitioner's counsel. Right to be heard, I do have that. So let me file within this week, my lord, we'll file it and let it be disposed of, my lord. Law is very explicit, my lord. A third party will not be given the right to, on the behalf of the accused who are standing in the character of an accused in a sessions tribal case, and on the basis of documents and incorrect statements, a case cannot be registered without being charged sheet being challenged in the court. That's my respectful submission at this stage, my lord. I reserve the right to file all these documents, my lord.
Lord, my learned friend is proceeding on the basis that Bansals are before the honorable court. My lord, Bansals have been charge sheeted. The present petitioner has not been charge sheeted.
That's
He
what I have the submission.
is the chartered accountant of the company. He deals with the financial matters. Therefore, he is in the know of things. My lord, I'll not say anything else. Kindly go by the status report, my lord. It merits registration of a case and investigation. Nothing else.
Let us hear him on the status report also.
Yes.
Let him have the copy and let him file the additional affidavit also. Everything
My lord.
within a short time.
Yes. My lord, may I kindly have a date next week, my lord, if it is possible.
27 will be out.
Date को साइड प्लान लोगों लेगा.
My lord will kindly call for the record, my lord, of that particular case also, my lord.
Yes,
It's
you
very
will.
important.
Who is there?
1189 of 2025. Who ukil ase etu? That is senior counsel Zial Kamar is there. And both can be disposed of that way.
Is your status report? Since you don't have any other, take this back and serve copies and one copy to the court.
Yes. কেতিয়া লব দাদা আপোনাক কেতিয়া
Next week?
next week নকৰো মানে ন
29. আগতে মই 29 কৈছো. নাই 29 আমাৰ প্ৰেছাৰ আছে না. Let it be on 29th.
My lord, I have a prayer, my lord, subject to my lord this. My lord, let it be on March.
Taken time
March,
earlier
no,
also.
no, no. That's not the thing, my lord. Let it be accommodating each other, my lord. May I pray, Itelobi. Person diary con.
Said you would file it within a week.
So maybe, my lord, itu kiti asu.
Today is 22nd.
February? Kiman tarik ke?
Have it sometime in February.
February, my
6th
lord.
of February, my lord.
5th of February? My lord, 5th of February will be my lord. Okay, my lord. Then till then, they will file with you.
In the meantime, they will file their whatever affidavit
Yes,
they would like
yes,
to file.
Yes.
Okay, and Chaudhary Learned Singh. The number?
Amar Kiman? 1189 of 25.
No, you are for respondent number.
Respondent number Kiman ami? 2. 1 ne 2 আমি ইমপ্লিট হৈছো তো 2 হ'ব নোৱাৰো এইটো সুধিছো বাবা
6 to file an
What?
additional affidavit.
4 to
record
6 minus.
certain facts not available.
They have already filed one additional affidavit.
আৰু এখন ফাইল কৰিম দাদা কি problem? ক'ত আছো
The matter again on 5th of
Okay.
February.
For further hearing, my lord.
Further hearing. In the meantime, the said additional affidavit filed with copies to the petitioner. Is this matter along with
criminal petition number 1189 of 25.
আমার উপর কি হয়ে যায় কেন করে কেন আমার পাস আমার লোক একদম deeply obliged.
Deeply obliged, my lord.
May it please your lordship. Lordship, this case, lordship, morning I have mentioned, lordship. Similar case, that case, lordship, when the person was picked up by the police in civil dress, lordship, the person raised an hue and cry, lordship. Day before yesterday, lordship has granted bail and other coordinate bench also granted bail, lordship. May I place the order of this court. On similar footing, only the date of arrest is different, lordship. Here, 1 and 2 is on 1st January and 3 is on 6th January. Oh, FR on page 70, that case lodged.
you are not ever named accused?
Here, lordship, petitioner number 1 and 2 is not FR name. Petition number 3 is an FR name. Lordship.
Also regarding that part, lordship, that that civil dress, they have been arrested, caught, lordship. That why that cannot be, lordship, that on what ground, on what situation that had been done, lordship. For that, lordship, call for, because lordship.
Yes, all fixed on 28. Analogous cases fixed on 28.
CD may be called for, lordship.
Interim दिया है सब. कोई कुछ के साथ सब interim दिया.
All around same.
Same case, same case. Anticipatory or anticipatory regular also is.
On one more thing,
This is also taking order dealing with. Was the same order on 28 cities coming, we decided. No need to separately call again for cities.
Interim lordship and provide.
Same one.
And item number 2 is for anticipatory bail lordship. Item number 2 for anticipatory bail, here also lordship. Yeah. We have to interim bail. Here coordinate bench order on page 22 lordship.
Fact that other co-accused were named and unnamed have been jailed by this court. The present case is of only one petitioner or two.
Here 2 petitions.
Bail of rupees 2 and each with 1 security of like amount each. Satisfaction of the this matter again on 28 along with give one number of any number.
All number lordship I have mentioned in
Item number 32. This will do. Agar item 2 number along with.
BA number 192/2026. Idea of this.
Item number 6.
May it please your lordship. Lordship, as per the last order dated, the record has been called for and the address C was not found. My lord, in the lower court, when we appeared on the last 2 occasions, the complainant was not present. It's been reflected in the last 2 orders of the lower court. In fact, we have been informed that he's under judicial custody also. So my lord, we may be allowed to take fresh steps upon the private respondent. Respondent number 2, my lord. And interim may be continued, my lord. Fine, yeah, he's under judicial custody.
But you'll serve him in jail.
Yes, my lord. The respondent number 2, my lord.
Right, it is submitted that service on respondent number 2 is not yet. Raise steps on the. There is allowed. So and so in pre-order first earlier will continue. This is given. Yeah.
Your Honor.
Yes.
Sir, office note dated 3/12/25.
Not complete. Any report from OC? Direction was to PS Ramnathpur, Hailakandi.
We send to the registry, then it will come to the registry on the next.
Come to registry only. Office note does not indicate service of notice upon the respondent number 2. Is the matter again on?
Lordship.
Please, Lordship, my lord, this matter relates to NI Act, my lord. Now, your Lordship is accused, was convicted by the trial court for simple imprisonment of 2 months and compensation amount of rupees 1,50,000. Now, my lord, learned appellate court has been modified, that is sentenced to pay fine only 1,25,000. Now, my lord, last judgment, impugned judgment, that is page 38, my lord. Criminal appeal number 7, page 38. My lord, we relied upon some decision of one of Supreme Court that also note, but has not been taken into account. Page 38, the impugned judgment, and here, my lord, relevant portion. In fact, page 41, in fact, in the fact and circumstance of the case, and considering the elapse of time, the order of sentence that is so-and-so passed by the learned trial court in chair case number so-and-so is hereby modified. And it is directed that the instead of simple imprisonment for 2 months and payment of rupees 1,50,000 as compensation under section so-and-so, appellant is hereby sentenced to pay a fine of rupees 1,25,000. Now, my lord, so far the cross part is concerned, it is a good case in favor of the appellant. That cross part is admitted fact. The check was issued as a blank. So blank check doesn't come under the purview of section 138. That is, kindly have a look, Lordship, page 36, the cross part of PW1. And legally enforceable debt is not established here, not proved. Page 36, the cross part of PW1. Here, my lord, relevant portion 37, from below 5 lines, my lord. From below 5 lines. At the time of availing the loan, accused issued a blank check in the name of the Samiti. So that check was filled up by the PW1. And a blank check cannot be a valid instrument under section 138 of an act. That is a settled principle of law. And so far the amount here saying that the money was given in cash, page 37, also admitted fact. The last line, the money was given in cash. So if cash, that has not been proved. Whether it was any application was furnished, admitted fact that the appellant was placed an application, that also not and could not be able to produced. And if loan was sanctioned, and sanction letter also not be proved. So it is doubt, my lord. This is the factual background, my lord. So appellant is entitled to be acquittal, and this judgment passed by the learned session court is to be set aside. And in this aspect, my lord, I would rely upon judgment, very remarkable judgment, that is lordship. On Rohit Bhai Jivanlal Patel case, here my lord saying, my lord, page para 16, because doubt arises when there is check, blank check, and it was in cash. Cash, if cash, then it is not a direct transaction. Para 16, my lord, para 16, 16 in court, para 28, page 119. Page 119, lordship, para 28. In the absence of compelling justification, lordship, page 119, lordship. Court para 28. In the absence of compelling justifications, reverse onus clause usually impose an evidentiary burden and not a purposive burden. Keeping this in view, it is settled position that when an accused has to rebut the presumption under section 139, the standard of proof for doing so is that a preponderance of probabilities. Therefore, if the accused is able to raise a probable defense, which creates doubt about the existence of a legally enforceable debt or liability, the prosecution can fail. So, legally enforceable debt is not established here because check was given in blank. So, when doubt arises, then the prosecution can fail.
But does it say that if the check is given in blank, then the doubt arises?
I'm coming to that right, my lord. One judgment, my lord, another lordship. C. Anthony, my lord, 2003, 1 SCC.
It only says once the signature is admitted, the presumption
They are
arises.
saying that if check was found blank is more doubtful because signature of the drawer.
Check was not
Signature
found
of
blank. How
the
can a
drawer.
blank check go to the bank?
Lordship, signature of the drawer and the amount of the pay, if found different, also it is doubtful. So this judgment very clearly saying, paragraph 8, my lord.
The present case, is that so? The figure and
This is also,
words
my
were
lord,
not
I have
matching.
written something here. Only one copy I have, that page, paragraph 8, my lord. So when there is different ink, it is also doubtful. And if doubt arises, and this Rohit Bhai Jivanlal Patel says that if doubt arises, the prosecution case fails. And one thing is very important, my lord, if loan given, where the sanction letter, where the amount, there is nothing established. So legally enforceable debt is very much important. So far, my lord, explanation clause of 138 is explained that legally enforceable debt is to be proved without any doubt. My lord, here, my lord, this latest judgment, Honorable Supreme Court says that in my lord Dashrath Bhai Tikambhai Patel case, passed by Honorable Supreme Court, comprising Justice Chief Justice D.Y. Chandrachud and Hima Kohli, my lord. Here, my lord, saying that in complaint petition, if it is not appeared that when check was deposited, the check represent the legally enforceable debt. That also not appear in the complaint petition. When check was presented, the check must represent the legally enforceable debt. Paragraph 16 saying, as it was blank. If the blank, but when it is deposited, it must represent the legally enforceable debt. Paragraph 16, my lord, I am reading about. Paragraph 16, my lord. The judgment of this court on post-dated check, as it was check, in my case, check was blank. When read and with the purpose of section 138, indicate that an offense under the provisions arises if the check represent a legally enforceable debt on the date of maturity. The offense under section 138 is typed by the disowner of the check when it is sought to be encashed. Though a post-dated check might be drawn to represent a legally enforceable debt, at the time of drawing for the offense to be attracted, the check must represent a legally enforceable debt at the time of encashment. So as it is admitted fact, check was blank. So when deposited,
At the time, was it blank at the time of deposit?
no, when the check was issued, it was blank, admitted. But when it was deposited, that means amount was filled up by the complainant. But in complaint petition, it is to be appear that at the time of presentation, this amount was enforceable and legally enforceable. That is not in the complaint petition. So this case is covered by this judgment, Dasharat by Tikambar pattern case, my lord. It very clearly narrated. The post-dated check, because this check was issued when, as they claim, amount was issued, amount paid, and undated check, blank check means undated check. And when they filled up the date and amount when filled up and when represent, but check should represent the amount. That has not been narrated in the evidence as well as in complaint petition. So therefore, this judgment clearly says that post-dated check also enforceable in under section 138, but it should be clearly mentioned when check was encashed for collection of the amount should be represented. That is not there. So this judgment is covered by this case, my lord. That is, therefore, my lord, I pray for setting aside this impugned judgment, and accused is entitled to be acquitted, lordship. Otherwise, my lord, they have failed to establish whether there is a legally enforceable debt and the amount was paid by way of some document. Nothing is there. No pronote, no agreement, no money received, and even any sanction letter. Only saying the amount was paid in cash. And also admitted the check was blank. But nowhere it is mentioned in the complaint petition that when check was presented for a collection of the amount, this amount was legally enforceable. That is not there. So Dasharat by Tikambar case is very good case, my lord. It covered this judgment. This is my humble submission.
Whether it is a suggestion, this cross of PW1,
yes, lord.
it is not a fact that the accused availed a loan of rupees 10,000 only.
Yes.
From the complainant.
Yes, this is a suggestion. Only 10,000.
At the time of availing the loan, the accused issued a blank check in the name of the Samiti. Is that also a denial or is it an admission?
No, it is admitted. My lord, this is one sentence. It is not a fact that the accused avail a loan of rupees 10,000 only from the complainant Samiti. This is suggestion, my lord. And admitted.
Look at the
last page, my lord. At the time of availing the loan,
inserted. So read together, it looks like a denial.
At the time of availing the loan, accused issued a blank check in the name of the Samiti. That has not been denied.
Where are you reading from?
At the time of this is fresh sentence, my lord. PW1. At the time of availing the loan, accused issued a blank check in the name of the Samiti. I studied up to class. So read
on.
I studied up to class 9. The president deposited the check in the bank. Exhibit 3 check was in the official custody of the precedent.
Then last line.
It is not a fact that we inserted the amount rupees 85,000.
That means it was not blank.
It is not a fact. So its suggestion was
Denied the suggestion that they put the amount there. They have reading together. How can it be considered as an admission that the check was blank?
check was blank, my lord. Check was blank.
No, you saying that 100 times will not do. You have to explain how it was blank. Where is PW2?
Record LCR also.
Okay, we'll see that.
And the contradictory, my lord. Here PwC 2 saying something and PW 1 saying another thing, not identical. So two things cannot be exist at a time, my lord. I have narrated in my ground, my lord, ground number 9, my lord.
Yes.
May I please, Lord?
Yes.
One minute, Lordship. Regarding PW1 and PW2, my lord, the ground number 9, for that it is admitted fact by the PW1, Sri Dipen Talukdar, in his cross-examination that at the time of availing loan, petitioner issued a blank check in the name of respondent number 2, which clearly established that the figure of the amount was filled up by the respondent number 2 himself, which is bad in law and it is not came under the purview of section 138 of an act. And so far PW2 is concerned, his my lord cross part was quite different, my lord. That is to be looking into account. And in ground number 4, for that the complainant Samiti is an NGO without having moneylender certificate to run the business of money lending. The complainant Samiti had failed to establish his case with regard to any power to give a loan to anybody else. Further, it is also admitted fact that the money as alleged in the complaint was given in cash. Therefore, benefit of doubt regarding sanctioning of loan has been arised in the case, in this case. So legally enforceable debt has not been proved. So far, prime ingredient of section 138 is concerned, Lordship. That is to be taken into account, madam.
Yes.
May I please,
respondent.
Lord? With all respect, your lordship, this criminal revision has been filed by the appellant, and we have also filed as respondent to the evidence objection in affidavit. In criminal revision petition, your lordship, page number 5, para number 4, they have categorically admitted, I am reading the line, that it is an admitted fact that the check in question was in blank while it was kept as security. So behind this sentence, it is there, intention shows the check was issued by the appellant himself towards the complainant side, that is respondent number 2 now. This is the admitted fact. Now, in regard to, my learned friend has said that from the beginning submission is there, blank check, blank check. Whether section 20 of NI Act did not authorize the complainant or the holder of the check to fill it up, I am reading the section 20. Section 20 of India's Negotiable Instrument Act 1881 deals with inchoate stamped instruments granting prima facie authority to a person given a signed, stamped, but incomplete instrument like a blank check or note to fill it out as a complete negotiable instrument, making the signer liable for the filled amount to a holder in due course, provided the amount doesn't exceed the stamp's value. It clearly speaks either blank or something else. the holder has the authority to fill it up. Now, Your Honor, my lordship. In the cross-examination part of the PW1 or in their opposition, no suggestion or no question has been put up in respect to the signature. So there is no dispute of signature. Now, another question. In their ground, they have taken that we have not taken the loan of 85,000. In ground number 8, that is page number 7 of criminal revision. For that, the petitioner avail only loan amount of rupees 10,000 only by submitting one loan application letter, which letter has not been exhibited by the respondent number 2 in this case. Through this paragraph, it is clearly seen that the appellant has admitted that I have applied for loan, whatever the amount is there. He says that I have applied for 10,000. It is his own admitted fact that I have approached before the person and I have applied. So behind this, now the question arises, that time liability. That is the foremost question of section 138 of NIF. This debt and liabilities has been clearly mentioned in our complaint petition. Page number 19 of criminal revision, paragraph number 4. The accused person issued a check bearing number so and so, dated so and so, for an amount of rupees 85,000 only, drawn on Central Bank of India, Vijayanagar branch, district Kamrup, Assam, so and so, in the name of Sanjeevani Samagra Vikas Committee, to discharge his aforesaid debt and liabilities. The said check was issued at the office of the complainant society. And the aforesaid liabilities is that the complainant society has given a loan of rupees 85,000 to the accused person.
Where are you reading?
Please.
Where are you reading from?
Which page?
Page number 18 and 19
The petition.
in the criminal revision petition.
Huh?
Para 3 and 4. That the above noted accused person personally approached to the complainant society for financial support to open income generating enterprises amounting to an amount sum of rupees 1 lakh only. The complainant financed the above named accused person as per his convenience, as per his requirement, with a sum of rupees 85,000 only. And this paragraph is categorically admitted by the appellant side from their grounds, and as well as also in their cross-examination, wherein they have put the question that we have only taken 10,000 only. So approach is their application.
You have admitted taking 10,000.
Lordship.
So why do you give a blank check? Why would you not put 10,000 there?
Lordship, that paragraph may kindly have a look, my lord. So far my learned friend saying.
Let me complete.
Page 19. I am repeating also from his argument.
Okay, you reply when your turn
Lordship,
comes.
Lordship,
Let him
because here no cause of action appearing. My argument was already advanced, my lord. Page 19, paragraph 3. When I approach, nothing is disclosed. And when I issue the check, nothing disclosed. So it shall established the check was blank.
Lordship,
Because question not arising when check was issued.
I am not saying
that
it is admitted fact by the appellant.
Lordship,
in this criminal revision.
That did the accused person issued a check bearing number so and so, dated so and so, but when check was issued, that was not mentioned. That it is undoubtedly a post-dated check, a blank check. So post-dated check does not come under the purview of section 138. It is a settled principle of law. And whether they are-
in the judgment cited by you wherein it has been held, it is applicable. Post dated check.
Poses check, but they have to mention when,
your
when it was presented for collection, whether this check represent this
Yes,
enforcement.
yes, okay.
That
Lord,
is-
you don't have to
So
intervene
far,
at every point.
so far, my lord, Dasharath
Make
by,
it quick, please. He has not
Dasharath by
completed.
Tikambar case is concerned, that is covered.
Let's say
Kindly
while
take your
completing
seat.
the points. The ground number 5, that is in page number 7 of criminal revision petition. They have taken the ground that for that the advocate notice does not contain the specific word demand in NI Act section 38, section subclause B, did not disclose for mentioning of demand. It's only disclosed that amount may be demanded. Either you show it is as demand or low. And in our notice, it is in page number 35 of criminal revision. It clearly says, it is therefore requested to pay an amount of rupees 85,000. This notice was sent to the appellant side in fourth para from the bottom, second para. Only to my client within a period of 15 days from the date of receipt of this notice, failing which
These grounds have not been urged by him, so you don't have to reply every ground.
grounds have been taken in the criminal revision, so that's why I'm.
Unless he urges them, there is no necessity. He does not press those grounds.
And in regard to ground number 10, in page number 7 of criminal revision, security check. Security check, post-dated check, all are under the PVO of section 138. And it is clearly mentioned in so many judgments by the apex court. And one of the judgment has been submitted by my learned friend. Once a check is issued, then the section 139 of the NI Act comes. When the holder completes the ingredients of section 138, that is ingredient number 1, check was dishonored, ingredient number 2, the notice has been issued, ingredient number 3, and complaint petition has been filed. All these ingredients are fulfilled by the complainant. Then it has been placed before the magistrate court, trial court, wherein the section 39 comes, 139 comes. And in this case, Rohit Bhai Jivanlal Patel, herein the Honorable in this case, page number 2.
Already here.
Already given this judgment.
The negotiable instrument, section 138.
One copy will do. Yes. Paragraph.
I'm reading the part.
Paragraph.
This is paragraph number 2, B. I think that is different from this.
Briefly put. What?
Little bit different. That is from it is from computer print, and that is I think from book.
You read your part, I'll find out.
Rule of evidence. Rule of evidence. Complaint under section 138 NI Act. Presumption under section 118 and 139 NI Act. Rebuttal by accused. To raise presumption, basic ingredients under section 118 and 139 NI Act have to be established, and these are established fact by the holder, that is the complainant. Once such presumption is raised, onus to rebut the same shift on accused. That rebuttal has to be done by the accused, not by the complainant, who is the holder of the check. And that rebuttal is to be cogent in nature, not just mere putting questions or suggestions. not just mere denying the part. Accused has to rebut the presumption by preponderance of probabilities, for which accused has to bring on record such facts and circumstances which may lead the court to conclude either that the consideration did not exist or that its non-existence was no probable that a prudent man would, under the circumstances of the case, act upon the plea that the consideration did not exist. This is the opinion of the Supreme Court. And now this has been done. And in our present fact and circumstances, there is no such rebuttal part by the appellant side that is originally accused. Your Lordship, some other judgments are also there in this regard. Lordship, I have only one copy. May I reading the main part of that? It is in Sampali Satyanarayan Rao, Indian Renewable Energy Development Agency Limited, wherein the Honorable Court, Honorable Apex Court has opined that negotiable instrument offense under Section 138 NI Act question whether dishonor of a post-dated check given for repayment of loan installment, which is also described as a security in the loan agreement, is covered under Section 138 of NI Act. In another one judgment, Apex Court opined that point for determination is discharge of a debt or liability in each and every case of check bounce. It's not for blank check or for any other thing. The fact that the details in the check have been filled up not by the drawer but by some other person would be immaterial. The presumption which arises on the signing of the check cannot be rebutted merely by the report of a handwriting expert. Once it's admitted that I have issued the check, and there is no question of objection in the signature part, Your Lordship, after going through all these submissions, my humble prayer is that the check which is in question and the present case, almost 10 years lapsed. After 10 years, it has come. So the check amount as per Section 138, it may be double of the check amount for compensation part. And all the ingredients have been fulfilled.
You filed a separate application for that.
Yes, Lord.
I have something to say. So far, my learned friend submitting admitted and saying that it was a security. Now, on that point, I would like to say, my lord, regarding this judgment, it is already argued that it was not blank but security. So I rely upon this judgment whether security check is come under the purview of section 138 of NI. The Supreme Court clearly saying that paragraph 5 clearly says that when a check has been issued as security, no complaint will lie under section 138 of the Negotiable Instrument Act. Paragraph 5, I relied upon. That is, I am taking the part from my learned friend, the admitted security. So if security, it is also not come under the purview of section 138. It is well known, my lordship. And another, my lord, judgment I am relied upon, so far argument relied upon by this, and another judgment that is very important, they're saying that 85,000 given in loan, but that has not been established. That is a legally enforceable debt. This judgment, MS Indus Airways Private Limited is saying that paragraph 19, that legally enforceable debt for a criminal liability to be made out under section 138, paragraph 19, lordship, there should be a legally enforceable debt. Issuing of check doesn't come under the section of this criminal liability. But very important ingredient, the enforcement, the legally enforceable debt, whether established or not, that is to be taken into account. Very clearly saying that for a criminal liability to be made out under section 138, there should be legally enforceable debt or other liability subsisting on the date of drawal of the check. On the date of drawal of the check, very important, lordship, because here in complaint petition nowhere mentioned when check was drawn. When check was drawn, it was not disclosed. That is the question. So this is also covered case. On assumption, one person cannot be convicted. Just issuing of check doesn't come under the section 138, criminal liability.
When check
Very
was
important.
drawn, it is immaterial.
That very old judgment.
When you have admitted
But
the
we-
part,
we have
when
to-
appellant has admitted the
This-
part that I have issued,
Dasharat by Tikambar Patel case, lordship, and this
whatever my learned friend presented this Supreme Court judgment and submitted that in para 5, it is a court of
Yes.
Kerala High Court. It is not opined by the apex court. It is a court wherein Kerala High Court, in a case given this part has been taken as a quoted, and this is not the preview is there. I have already submitted the Honorable Apex Court judgment.
Yes.
Value, please.
Lordship,
Sir, para 5, you did not read after para 5.
para 5.
You relied on para 5. That is only quoting of the High Court judgment.
This is also one
But
of
what did the Supreme Court
observed.
ultimately hold in the said judgment?
This is
Don't waste my time, please. Yes. All right.
And therefore, my lord, paragraph 13 saying the High Court fell into a manifest error, and as such, the judgment impugned cannot obtain our accordance, the appeal succeed, and is thus allowed. So, my lord, so far explanation clause of 138 is concerned, legally enforceable debt, that is to be taken into account. And so far, Dasharat by Tikambar Patel cases, that cannot be overlooked. Because they totally fail regarding the sanction amount 85,000, when issued, when sanctioned, and when received, nothing is there. Only
My dear
explanation,
learned-
only saying
My dear
explanation.
learned friend, you have already admitted that part.
Only 10,000 liability, my lord.
Yes. CIB.
Highly obliged.
I leave.
Made please, Your Lordship. This is an appeal against conviction. The appellant was convicted under 304 and sentenced to 10 years. But my grounds of appeal is main ground during the time of trial. In fact, prior to the trial, he was mentally unsound. In fact, the order sheet of the trial, learned trial court reflects this. Now, under the mandate of 328, 329 CRPC, if a person is found to be mentally unstable during or before the trial has to be stopped. Subsequently, the factum of his mental illness, whether he has been cured completely, has to be first taken into consideration. Once that has been arrived at, then only the trial can proceed. Now, in this case, my lord, that mandate that he was sent to this Tezpur Mental Hospital, Lokopriya Gopinath Bordoloi Hospital, he was sent by the court. But there's an order of the learned trial court which says that he was discharged, seen the discharge certificate, he is fit to stand trial. Now, there's a judgment of this honorable court by a division bench which said that you have to first inquire into his mental state. When he has been discharged, you have to take evidence of the doctor who has treated him, that whether he is capable of entering his defense. That part has not been done in this case. And in fact, the cross-examination of all the witnesses, they have stated that he was mentally unsound. Prior to the incident, he was taking medication and all. If your lordship allows me to take lordship to the evidence. My lord will have to rely on the LCR, TCR for the evidence.
Whether anything regarding that mental aspect has been reflected in the impugned judgment?
My lord, if judgment paragraph 57, my lord.
55 onwards, my lord.
55 onwards, my lord.
From page 55.
Oh, sorry, not appeal.
Page 55 of
Judgment, my lord.
judgment is
Relevant
42
paragraph,
pages.
yes, page 55, page number 55 of my appeal memo, my lord. Paragraph 57.
Inner page of the judgment?
My lord, 37. Page number is at the bottom. Paragraph 57, my lord. At this, I would like to mention here that though in the course of argument, hearing learned counsel for the advocate for the accused has argued that accused was not mentally fit, but from the evidence available on record, particularly from the admission of PW4, the father of the accused, during cross-examination, it revealed the accused was mentally ill prior to the incident. At the time of incident, the condition of the accused was not so bad. Moreover, the wife of the accused, that is PW12, in her evidence has categorically admitted that the accused is suffering from sleeping disorder only. Her husband can do other activities. He can count money. Sometimes he makes wrong counting due to his mental disorder. He can do other activities like taking meals, bath, etc. He also knows to show care to his daughter and her. His other activities are found to be good. He only creates problems whenever he does not feel sleepy. Apart from above, during long trial process, no plea of mental illness was taken. An accused regularly attended the court and was found mentally fit during his examinations under 313. Hence, the plea of mental ailment neither exists on the date of incident nor during the trial, and hence said plea raised by the learned advocate for the accused could not be accepted. Now, in this regard, my lord, if your lordship takes up the order sheet of the trial court, my lord will take up order dated 31/2015, 1/5. 301/2015. My lord will write the date of occurrence is 21/2014. I think it will be page number 4 or 5 of the lower order sheet. I have put a flag mark, my lord.
Page 3.
Pink flag mark. 2015. Accused Ratan Medi is produced from custody. It appears from his behavior that he is suffering from ailment. As such, the Superintendent District Jail Morigaon is directed to produce the accused immediately before the Superintendent Morigaon Civil Hospital, who shall examine the accused thoroughly and submit a report to this court within 7 days. Send a copy of this order to so-and-so, fix 6-2 for production. Next order, my lord. This order was not complied with. So, an explanation was called for on 6-2, and Registrar of this court is directed to obtain report from Superintendent Morigaon Medical Hospital if accused Ratan Medi was produced and already examined. Then, my lord, 7/2015 order. Case record is put up. Seen report of Medical and Health Officer Jail Morigaon. It is stated that UTP Ratan Medi has been suffering from certain psychiatric illness and he was last sent to this hospital on 2/1/2015. He has been referred there on 3/2/15, but it was not mentioned the present condition of the accused, whether he is still suffering or recovered. Then observations were made. Third paragraph, from the above report, it appears that examination of the accused Ratan Medi by a psychiatrist is necessary to proceed with the enquiry trial of the charge brought against him. So, Superintendent District Jail Morigaon is directed to produce Ratan Medi on Monday so-and-so before Dr. J. Datta, psychiatrist of Morigaon Civil Hospital, to examine the accused, as psychiatrist of Morigaon Civil Hospital is attending on Monday and Tuesdays only. Next line, madam. Dr. J. Datta is informed to examine accused Ratan Medi thoroughly and submit his report within 13/2/2015. Dr. J. Datta also directed to appear before this court personally for his examination under 325 CRPC along with examination report of accused Ratan Medi. My lord, this is very important. A copy of this order be sent. Next, my lord, 13/2. Accused Ratan Medi is 13/2/2015. Accused Ratan Medi is produced from custody. Psychiatrist J. Datta is of Morigaon Civil Hospital is present. He has submitted report in compliance with the order dated so and so. I have gone through the report. It disclosed that he examines Ratan Medi on 9/2/15 at 10 a.m. at OPD Morigaon Civil Hospital. On examination, Ratan Medi is provisionally diagnosed as suffering from major mental disorder and needs further treatment regularly immediately. Heard Dr. J. Datta personally, who is present today. In his personal hearing, Dr. J. Datta stated that the patient Sri Ratan Medi requires immediate treatment and is not in a position of a normal person at present. I have gone through the case records. The allegation against the accused Ratan Medi is under section 302 and trial is going on. From the personal hearing of J. Datta and also from hearing the accused Ratan Medi, I am of the opinion accused Ratan Medi is incapable of making his defense due to his mental disorder. So, trial of this case is postponed under section 329 CRPC till recovery of mental disorder. Accused Ratan Medi is an under trial prisoner and is in custody. Considering the urgency of treatment of Ratan Medi as he is suffering from mental disorder, medical superintendent so-and-so is directed to admit Ratan Medi and treat him till he becomes fit to stand trial. He will submit monthly progress report about the condition of the accused Ratan Medi to this court. Then the explanations are there. This order is of 13/2/2015. Your Lordship will keep that note of that. My lord, we come then 9/4/2015. The handwritten order, small order. PO is on leave. Seen the report received from LGBI Tejpur as had stated that Ratan Medi was examined and diagnosed as having schizophrenia and is now undergoing treatment. 19/5/2015, again, my lord, diagnosed of having schizophrenia is undergoing treatment. Now, my lord, 26/2015. This is very important. PO is on leave. Accused Ratan Medi is produced from custody. He is remanded to custody till next date. Seen the report received from so-and-so, Tezpur, accused Ratan Medi is discharged from hospital and fit to stand trial at present. Hence, the case is fixed for evidence. And the mandate of 329 says you have to examine the doctor. And schizophrenia, my lord, it is not that he was having any other minor issue. 19/4 and 95 says, 19/5/15 says he's suffering from schizophrenia. 1 month after that, he's out of schizophrenia. The doctor who had examined, the division bench of this court has said that you have to need to examine the doctor, that whether that person is able to stand trial or not. They have gone only by the discharge certificate. My discharge certificate may mean that I no longer need to be in the hospital. Lordship may take it like that. I have broken my leg. I cannot run a 100-meter race, but I can at least walk by limping. That does not say that I'm completely fine. The entire trial, my lord, going by this fact that 328, 329, 329 basically rather not being complied with, the trial is vitiated. Your lordship wants to go through the evidence, I can take your lordship through it. Every witness has in his cross-examination admitted that he was suffering from mental. In fact, 1 month prior to the incident, he was admitted to Tezpur Mental Hospital. In fact, till this day, my lord, this person is not of sound mind. The order sheet will reflect that. Order sheet of this present proceeding. If your lordship takes up order dated 24/7/23 of the criminal appeal. 24/7/2023. First order of admission, my lord. And last paragraph of that order. Also call for a health status report of accused appellant supported by documents from the superintendent Morigao jail in consultation with the jail doctor. My ground for admission was that, my lord, this had come to the court itself. I don't know whether a copy of that is not 7th August 2023. This was the report from the jail. The forwarding report from jail to the Honorable Guwahati High Court, Guwahati. Next page is the report. Medical report of convict Ratan Medhi, vide memo number so and so. I have the honor to state that the convict Ratan Medhi has been examined by him. He is a psychiatric patient under continued treatment of Morigao Civil Hospital. The doctor, he is being given medicines as per advice of Morigao Hospital, which are so and so medicines, my lord. He is under continued treatment, check-up of Morigao Civil Hospital, psychiatric doctor. At present, he is not doing well. My lord, there are two facets of the matter. At present also he is not doing well. That's a separate issue altogether. There are provisions of law for that. But on the during trial, the order sheet of the court says that he was not keeping well. And the factum of the mandate of 329 was not followed. In that regard, my lord, I would like to place one judgment of this honorable court, the division bench judgment. 2012 1 GLR, page 115. My lord, will take up page 123, para 32. This is the facts of this case. I want to point it because it's very, it's almost equal to my case. Para 31, my lord, the learned amicus curiae has submitted that the accused was suffering from schizophrenia, and as such, due to such mental illness, he is in fact did not know what he was doing or what he was saying. Therefore, it is submitted that as the accused due to his mental illness could not realize the implication and legal consequences of making statement under 313 CRPC, his statement admission made under 313 cannot be used against him. This was the argument placed. 32. Admittedly, the PW2 clearly stated that the accused was suffering from mental disorder. The order sheets, order dated 11/12/2001, maintained by the learned trial judge, reveals that the learned chief judicial magistrate on 18/8/2001 directed to send the accused to the LGRBM Tezpur for proper treatment. Though he was sent to the same institute on 19/8/2001, the authority returned him from want of seat with instruction to send him after 3 months. Thereafter, the accused was sent to so-and-so on 23/11/22, and order dated 4/9/2003 revealed that he was returned with the certificate that he had recovered considerably. The said certificate has not been proved, and the learned session judge fixed the case on 30/9/2003 for framing of charge. And same here. And next, if your lordship comes to next page, 124. Yes. Now, there's no paragraph number, but the paragraph starts from the above, in the middle of the page, page 124. Basically, third paragraph, my lord. From the above, it is clear that as per the order dated 18/8/2001 passed by the learned CJM, the accused was required to be taken to LGBRM at Tejpur, but he was not sent to Tejpur on 19/8. On 4/9/2003, he was produced in the court along with the report that he recovered considerably. This implies that he did not recover fully. Again, he was required to be sent to Psychiatric Department, Silchar Medical College. On 24/3/2005, from the report of the Psychiatric Department, the learned session judge found that the accused was fit to face the trial. Therefore, admittedly, the accused was found to be mental patient as on 18/8/2001, and the trial could not be proceeded with till 7/4/2005. That is the date on which charge was framed. Therefore, considering the fact that the accused was required to be sent to so-and-so Tejpur as well as Silchar Medical College due to his mental disorder, the evidence of PW2 and the evidence of PW2, we don't find it safe to brush aside the contention raised by the learned amicus that the accused at the time of occurrence was suffering from mental illness. Then, my lord, next page, page 125, section 329 is quoted, paragraph 36, paragraph 37. As provided by section 329 CRPC, the trial court dealing with a person of unsound mind in the first instance is required to try the fact of such unsoundness and incapacity. In the present case, as per the report issued by the LGBRM Tejpur, the accused had recovered considerably, and thereby meaning that he did not recover fully. That apart, subsequently, he was required to be sent to Psychiatric Department, Silchar. The trial court, on the basis of the report not proved, similar case, my lord, here, issued by the petitioner, Psychiatric Department, Silchar Medical College, concluded that the accused was fit to face trial. In fact, the learned judge neither recorded as to what were the findings regarding the mental health of the accused, nor examined the medical officers who examined, treated the accused, and submitted the reports. Therefore, it is found that the learned trial court did not try the fact regarding unsoundness and incapacity of the accused. And the discharge certificate itself is not on record. It has not been proved who has given the discharge certificate. The doctor who was specifically said, Mr. Dr. J. Doctor, who will be treating the patient, he is never, not before your lordship. He was never before the learned trial court to say that this has happened, this treatment was given, now he is out of all the issues. This was never done. So the mandate of 329 was not at all followed. Paragraph 41, my lord. Why the person who is not mentally sound, his trial is vitiated? Because the paragraph 41 explains it properly. Considering the entire aspect of the matter, we have no hesitation to hold that the accused was suffering from mental disorder. The examination of the accused person under 313 CRPC is not a mere statutory obligation, not a mere formality. The purpose of such examination is to provide sufficient opportunity to the accused person to explain the circumstances and incriminating evidence brought against him. During such examination, the attention of the accused is required to be invited to the incriminating evidence and the circumstantial evidence relating to the offense for which he has been charged. It provides the opportunity to the accused to state before the court as to what is the truth and what is his defense in accordance with law. Therefore, before an accused is examined under section 313 CRPC, the court must ascertain that the accused person is mentally fit to properly understand the legal implications of the incriminating evidence materials brought against him and the questions put to him. Unless he properly understands the legal implications and the consequences thereof, it will not be proper to use the answers admissions given by him. Paragraph 43, in view of above, it was the duty of the learned trial judge to come to a definite finding on the basis of the medical evidence regarding the mental health of the accused, and the learned trial judge should have taken resort to the provisions provided by section 329. Subsequently, since this was not done, in this case, the person was acquitted. In our case also, if your lordship wants to go through the evidence, every witness has stated that he was mentally unsound during the time of before and during the time of the incident. Now, there are two facets of insanity, my lord, under the law. One is section 84 IPC, wherein I take the plea that I am mentally unsound. That is under general exceptions, which holds private defense also, or intoxication on my part. I have to prove that. CRPC 328, and for this case, session case 329, if the learned court feels that something is wrong with the accused, I need not take a defense. Here, the court on itself has said that when he was produced, court said that by his demeanor, I don't think he's normal.
Of 84 is different.
yeah,
Suppose
my lord,
trial
yes.
is going on, they take up a plea that at that
That's-
time he was,
My lord,
but he may be
yes.
fit to stand trial
Yes,
today.
yes, exactly, my lord. Today he may be fit to stand trial. That's a different thing. But 329, the court has come to a finding. 465 here. Court has come to a finding, court has come to an observation that he is not a normal person as of date. So that factum of his mental unsoundness, as per this judgment of 2012, you have to first come to that. That today he is out of every issues and he can face trial. Not going by the mandate of 328, 329, directly brings in the provisions of section 465 CRPC. 465 says finding or sentence when reversible by reason of error, omission, or irregularity. Subject to the provisions herein before contained, no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation, or revision on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceedings before or during trial, or in any inquiry or other proceedings under this court, or any error, irregularity in any sanction for the prosecution, unless in the opinion of that court, a failure of justice has in fact been occasioned thereby. And not following the mandate of 329, as per our High Court's judgment, it's a failure of justice. Whatever, in fact, my lord, that judgment, what had happened in that judgment, this person, he was charged with 302. He had said that I had not committed the crime at the time of framing of charge. But at 313, he accepted everything. Court had come to a finding that you have to even look at to that fact that that time he did not say that he had committed the crime 302 during the framing of charge. Why today he has gone to the fact? I mean, I had this marked. Paragraph 45. Fact remains that at the time of framing the charge, the accused person categorically denied the charge brought against him and he claimed to be tried. There is no explanation as to what prompted the accused person to admit the allegations brought against him at the time of his examination under section 313 CRPC. Considering the mental condition of the accused as indicated above, it is doubtful if he understood the implication and legal consequences of giving answers in that way. Same is the case in our matter. Yes, I was charged under 302. It was converted to 304 because evidence says I was sleeping. The deceased had come. He poked me. He disturbed me. I went out. I hacked him. That's why it was brought to 304. But that does not matter whether it's 302 or 304. The entire case that I cannot stand trial, that has not been gone into. In fact, the order sheet is very clear. The court has identified the doctor who will treat him. It is not that prosecution case can come and say, we do not know which doctor treated him. The doctor was even identified that so-and-so will treat him and he has to be brought and he has to depose. Preliminary, he had said the person is suffering from schizophrenia. This judgment also says what schizophrenia is. As of today, 5 years of sentence he has completed right from the day of his arrest. In fact, he was order sheet, if your lordship sees order. So he was given bail during the trial, but he had to again be brought back because he was creating problem at his house. That is my humble submission. His entire trial is vitiated because the fact number 329 was not looked into. Obliged.
Regarding the my lord, schizophrenia, my lord, they have taken the my lord plea on the court below also, my lord. But in the judgment, my lord, I have already read my friend, my lord. It was discussed, my lord, and rejected court below. And one important thing is that, my lord, PW12, my lord, wife of the present petitioner, my lord. She was the eyewitness, my lord. She said about what he can do, what he cannot do. He said he will mentally fit, my lord. PW12, my lord. I have checked mark, my lord. From our statement, it is clear that he is mentally fit, my lord.
Schizophrenia has many aspects. You
Fine.
may be doing all your regular activities.
My lord. And
All right.
T13
Then
statement, my lord.
suddenly you can do something else, which is quite inexplicable.
In 313 statement also, my lord, whatever he was question put to him, my lord, he has answered, my lord, in his own, my lord. And in the last portion, my lord, in the 313 statement, my lord, he was, what you want to say something, my lord, anything you want to say something, last question, my lord. He said that, my lord, when that fact, what he done, my lord, he admitted. He said that when I was sleeping, my lord, then uncle, my lord, uncle went there and some, my lord, he, in anger, my lord, he assaulted with an ex, my lord, and died. But other questions, my lord, other questions, as per, my lord, his knowledge, my lord, that cannot be considered, my lord, that he is, my lord, from the 313 statement, my lord, it reveals that he is the fit person, my lord. Other questions he put by the court, my lord, he given the answer, my lord.
Can that cure the initial defect in not complying with 329?
Yes. Record on record, my lord, that are on record. But considering all the aspect, my lord, court below has rightly passed the judgment, my lord. Only given the lenient view, my lord, the presence of witnesses, my lord, he has killed the.
How many years he has been sentenced?
My lord, 10 years, my lord.
10 years sentence to 10 years.
Initially, it was 302, my lord. It was then considered under 304 part 1, my lord. Part 1, my lord. My submission is that court below has rightly passed the judgment, my lord, and already discussed all the things they have taken plea also. His opinion, my lord.
Yes, I will not read it properly, Lordship. Paragraph 40 of this judgment that I quoted, that's amply says what schizophrenia is. Paragraph 44(0).
And also in the my lord, PW12, my lord, in a statement category stated he was admitted to the, my lord, Tezpur, my lord, Lokapura Gopinath Ballai Mental Hospital, my lord. Thereafter he was released, my lord. Then thereafter he is fit person, my lord. That is there, my lord. PW12, my lord.
What is said in the discharge certificate, even that we do not know.
Yes, ma'am.
But it was said in the in a statement, my lord, it is improved and it mentally fit.
Not to say, my lord, the order that discharge certificate says PO is on leave. So obviously that is written by the court master, signed by the whoever the in charge judge that time was.
This is what I find surprising when this is a consequential decision. So when PO is on leave, the normally does not pass any kind of order such as this. That is why I find it quite surprising. Has happened, has happened.